I now call to order the 158th meeting of the Standing Committee on Citizenship and Immigration, and today we begin our consideration of Part 4, Division 16 of Bill C-97, an act to implement certain provisions of the budget tabled in Parliament on March 19th, 2019. For this first session, we have Minister Blair and his officials with us. My understanding is that Minister Blair has a presentation of about a little less than 7 minutes, so we will start immediately with that, and hopefully we can get our full 51 minutes of questioning in. Mr. Blair.
Thank you very much, Mr. Chair, and I'll try to get through this as quickly as possible. I'm very happy, and thank you for the opportunity to appear before the committee today. Happy to speak regarding our asylum system and border enforcement proposals that we have included in Bill C-97. Mr. Chair, we are in a world that is experiencing unprecedented levels of migration. The United Nations Refugee Agency has estimated that there are approximately 258 million people who are now on the move globally, including economic migrants, but that 25.4 million of those individuals are deemed to be refugees, those who are fleeing war and persecution and seeking protection. And like many other countries in the world, almost every other safe country in the world, Canada has seen an increase in migration. The growth in global migration suggests that higher numbers of asylum seekers are likely to continue and points to a need to continue to ensure that our borders and asylum system are well managed to meet our international and Canadian legal obligations. It's imperative that we maintain a refugee protection system that is predicated on two important principles: fairness and compassion. And Budget 2019 has proposed to invest $1.18 billion over a 5-year period, starting in 2019-2020, with $55 million per year ongoing to enhance the integrity of Canada's borders and our asylum system. These investments also support the government's border enforcement strategy and will increase the asylum system's capacity to handle higher volumes of claims in order to provide timely protection to refugees and ensure that a failed asylum claimant is removed quickly and compassionately from our country. The border enforcement strategy includes detecting and discouraging the misuse of our visa system by preventing travel to Canada by individuals who may not be legitimate temporary visa applicants. And this means investing significantly in intelligence gathering and trend analysis to limit the number of Canadian visas issued to people who would use a Canadian visa only to establish themselves permanently in Canada. We are also continuing to work with our international partners to share information and trend analysis that may impact visa issuance. Increasing the interdiction of would-be irregular migrants abroad has been significantly increased, and engaging recalcitrant countries in support of removal operations by obtaining their cooperation in a timely way for the issuance of travel documents for failed asylum claimants after they have exhausted all legal recourse in Canada. And also by discouraging would-be irregular migrants by a targeted outreach, by correcting misinformation and providing the facts about Canada's asylum system to make sure that people understand our laws and how this system works. Mr. Chair, the border enforcement strategy also will maintain the integrity of Canada's border. We are investing in an ongoing building of capacity for interceptions between ports of entry as the Royal Canadian Mounted Police continue to increase its capabilities at key locations at the border and invest in new border technology equipment. We are putting in place contingency measures to ensure that we are ready to respond to any potential increase in the number of irregular migrants. And we have introduced legislative changes which we believe will improve our ability to manage flows along the border in the event of any increase and influx. And this includes, for example, an amendment which will eliminate the 3-day time period for officials to determine if an individual is eligible to make an asylum claim before the claim is automatically referred to the Independent Immigration and Refugee Board. Removing this requirement will give the government greater flexibility to manage volumes at the border and to ensure that everyone is examined properly and in a fair way. We are also putting in place measures to discourage irregular migration by those who try to make multiple claims in different countries. And this is described in the BIA legislative change. And just like other existing ineligibilities, these individuals will be barred from accessing the Immigration and Refugee Board. And instead, these individuals will have access to an enhanced pre-removal risk assessment, or the PRA, prior to removal, to ensure that they are not returned to a situation of risk. Mr. Chair, I think it's very important to emphasize that no one who has been barred from accessing the IRB as a result of this new measure will be removed without a PRA hearing. This proposed measure will also help lessen the caseload at the IRB, while ensuring everyone receives fair treatment before any removals take place. Mr. Chair, we maintain public confidence in our system by treating those who cross irregularly exactly the same as those who currently do so at regular points of entry, as a means of eliminating any incentive or perception of unfair advantage. And in addition, we're continuing to engage the United States to modernize and enhance the Safe Third Country Agreement. The Government of Canada has been in continual contact with the U.S. government on issues related to our shared border. And I wish to advise you that I have recently met with numerous stakeholders, including U.S. members of Congress, Customs and Border Protection, the Department of Homeland Security officials, and we are seeking to enhance U.S. cooperation to address irregular migration challenges, including the modernization and enhancement of the Safe Third Country Agreement to the mutual benefit of both countries. Canada and the U.S. share a mutual interest in ensuring the orderly handling of asylum claims while protecting the safety and security of our citizens, respecting the rights of those who are fleeing persecution. We are investing in an asylum system that will be fast, fair, and final. We are increasing funding for the asylum system as a whole to process higher volumes of claims. This will allow the IRB to make decisions on up to 50,000 asylum claims and 13,500 appeals by fiscal year 2021. And with this additional funding, the board will be able to finalize more decisions, thus reducing wait times for those in need of protection and leading to faster and more efficient removal of failed claimants. I would also note that in recognition of the increasing volume of asylum claims, we're investing more in settlement funding as more people will be given protected persons status. And given that protected persons are eligible for settlement services such as language training, this investment is actually an investment in the future of Canada. In addition, we are increasing funding to allow for timely removal of individuals who are found not to be in genuine need of protection, and we are taking measures to expedite the removal of failed claimants who cross irregularly into Canada. And finally, with the Budget 2019 investments and with the legislative proposals that we bring before you today, Canada will continue to respect its international obligations for people who are legitimately fleeing persecution and achieve finality in our asylum system. Thank you, Mr. Chair, and I welcome your questions.
Thank you very much, Minister. As you members are aware, we'll do our best to restrict the questions and comments to Part 4, Division 16, but this is discussion and commentary on the budget, so I think we'll appreciate that it might be a bit farther ranging than that. Ms. Said? Oh, sorry, Mr. Taber.
Thank you, Mr. Chair, and thank you, Minister, for being here today. We just finished a study on global migration and the numbers that you've given us. We know that around 258 million people are on the move. Many of those numbers are refugees, as you mentioned in your statement. And you mentioned in your statement about investing at the border, and ensuring that our borders are secure and we make sure that the men and women that are working at the borders have the proper tools, and that the federal government are investing in that so we maintain our integrity at the border. However, in previous years, there's $143 million cut to CBSA. So I want you to just mention on that is that when we're seeing this new global trends of 250 plus migrants on the move, we better be prepared that we're investing in our borders, or else we may see a situation where it's hard to handle. But I wanted you to comment on that since the time that you've been in office. What are some of the changes that you've seen? There's been cuts before, and now we're investing. I want you to elaborate on that.
Yeah, we've been doing a number of things that are important, and frankly, I want to share some good news with this committee. We have seen significant reductions in the number of people who've been presenting themselves irregularly at our border and then subsequently making a claim for asylum. So far, year to date, about a 47% reduction in the number of people who have crossed our borders irregularly. And that's a direct result of some very effective interventions that our agencies and officials have been undertaking, outreach into the populations in the United States and elsewhere around the world to provide them with better information about our system, and because there's a great deal, unfortunately, of misinformation and people who would exploit those who are in a vulnerable position, which has, I think, contributed to that influx of people at our border. We've also been working very closely with U.S. and other international officials with respect to the issuance of visas. We saw, for example, from one particular country in Africa, a significant number of people who were issued tourist visas to come to the United States who subsequently presented themselves at the Canadian border seeking asylum. As a direct result of interventions made with U.S. Border Patrol officials and their visa issuance systems, and through investments made by CBSA, who put officials overseas to work collaboratively with the U.S. officials in issuance of those visas, we've achieved a 73% reduction in the number of individuals coming from that country through the United States who subsequently present. But one of the things we found, and I hope this gets to the answer of your question, we needed to significantly increase as well the capacity of the IRB to conduct timely hearings. Their ability to conduct those hearings was resulting in them falling further and further behind due to the volumes of people that were presenting, not just irregularly, but we've also seen a significant increase in the number of people who are crossing regularly at airports, regular points of entry, and making inland claims. And so we needed to invest in IRB's capacity to do timely hearings. We've made an investment last year, some $73 million, to begin to build up their capacity. It significantly improved their ability to deal with that backlog, but we recognize that more needed to be done. That's why in Budget 2019, we're adding over $207 million to IRB with the intent that by 2020, they'll be able to process 50,000 claimant hearings each year. And as a result of better administration of those hearings, more timely results are being determined. The amount of time it takes to resolve these eligibility claims is being significantly reduced. And in achieving that reduction, I think we were able to create a system which is much more balanced and by which people have a reasonable expectation. If they are in need of protection, they'll receive it in a timely way. And if they are not in need of protection, they'll also be removed from Canada in a timely way.
With some of these amendments that are being put forward, can you elaborate more on our international obligation and the global impact on migration that the UN report has put out? And are we ensuring that our immigration system is fair and compassionate to those who are coming to our borders?
Thank you, Mr. Moran. I will tell you that one of the pillars, the values in which I believe our immigration refugee protection system is based is one is both fairness and compassion, and one which upholds our international obligations and the rule of law. And we have ensured in every step of this process that we have complied with those requirements, not just with the letter of the international law, but with its spirit as well. I am very gratified by the support and the comments made, for example, by UNHCR, the United Nations Refugee Agency, which has acknowledged that Canada, throughout all of these changes that we're making and investments we're making at all times, maintains and upholds its international obligations to provide people with access to due process and a timely determination of their eligibility, and that, as well as a direct result of the investments we're making in IRB, that Canada is maintaining a world-class asylum determination system. I've also had the opportunity to meet fairly recently and spent a lot of time with Amnesty International when I explained exactly how our system was working and was able to provide them, for example, with reassurance that any individual, regardless of whether or not they're eligible to have access to the IRB, before they would be removed from Canada, regardless of the circumstances under which they have come, they would be afforded an enhanced pre-removal risk assessment, and that according to our laws, they would always have the opportunity to be heard, have legal representation. And if there was a determination that they were at risk, we would not send them back into a dangerous situation, and instead they would be afforded protected person status.
Just about.
And real quick, you referred to our system as fast, fair, and final. Can you just elaborate on that with?
Yeah, I think in order to be a properly, efficiently managed system and to maintain a system of fairness, people have to have an expectation of a timely determination of their application. And what we found is that as a result of under-resourcing and a lower, an inadequate capacity of IRB to come to a final determination, that it was taking a very long period of time. That delay actually contributes to the unfairness of the system. It leaves people who truly are in need of protection in an unresolved situation, which does not contribute to their settlement and integration into Canadian life. And at the same time, for those who were not eligible for our protection, the long delay served as a bit of an incentive to make application and to be engaged in that process. And so making that fast is an investment that actually also contributes to its fairness.
Thank you, Minister. I think we'll get to that further questioning. Ms. Rempin.
Thank you. I think maybe we should just cut the baloney. So you are sitting here, Minister, in an invented position with bureaucrats that don't report to you, but nonetheless have the misfortune of working with you. And we are in the final days of a parliament where we've seen your government purposefully go out, and again, regardless of your opinion on the American president, poke the Americans in the eye with hashtag welcome to Canada, then allow 40,000 people to illegally enter the country, and then claim asylum while saying that the Safe Third Country Agreement upholds, but then putting in place a permanent tent city, busing programs into the GTA, spending hundreds of millions of dollars on hotels for people that likely, by your own colleagues' admission, don't have valid asylum claims. Then you proceeded to vilify any Canadian who said, you know what, maybe people who are in upstate New York don't have the same level of years-long backlogs. You know, you vilified anybody. Your colleague, the Minister of Immigration, the Prime Minister himself, tried to score cheap political points with hashtag welcome to Canada, then un-Canadian questioning, you're racist if you question this, inflamed tensions. You know, you yourself sat here and you blustered, we can't call it illegal. And then you proceeded to spend hundreds of millions of more dollars on this program. You ramped up the rhetoric until we got close to an election. And then all of a sudden we have Division 16 in the Budget Implementation Act, measures that have been routinely panned by virtually every immigration professional in Canada, not likely to uphold any sort of court challenge whatsoever. And frankly, people will testify during these hearings that are likely to have even more of an administrative backlog and burden on the system. You then proceeded, and your colleague did, to blame the situation on Stephen Harper, which, good on you. You've got to do what you've got to do as being paid to be a communicator. But the reality is that you've inherited a 10,000 case backlog, which of course was brought down after a massive backlog. This is the IRB after a previous Liberal government. And we're now at 71,000 case backlog, according to the Auditor General today. A 71,000 case backlog at the IRB. You said that the system is fast. So fast is 5 years plus to have a refugee claim hearing. You also added to the backlog by lifting the visa requirement on Mexico when your government had not done a formal review of the system. We're now seeing, I believe in the last 2 months, it was over 1,500, claims from Mexico. We know that the determination rate of those claims of validity will be about 22%. The average caseload right now, or the average level is about 55%. So we know that many of these are bogus claims. So your government, one could argue, has managed the asylum system when I believe that we should have a strong asylum system. We should be allowing people into the country who have legitimate needs of persecutions, but you've managed this like it's this joke for votes. Fast, come on. Really? Stephen Harper's fault? After you've got, when we form government in October, we're going to have to clean up a 120,000 case backlog left by you. And now, at the end of the dying days of this parliament, all of a sudden when you see polling that your mismanagement of this is somehow unpopular because people are going, this isn't fair, all of a sudden now you throw something into an omnibus budget bill, which, I had a colleague on this committee had to fight to get it parsed out to review here. We only had one piece of legislation come through this committee in the entirety of this parliament, and it's not even going to work. And it's probably illegal and unconstitutional. You haven't even picked up the phone to the Americans. Literally, your department sat here and we asked them, when are you has the government given you any direction to implement closing the loopholes in the Safe Third Country Agreement? The answer, just, Minister, in case you weren't briefed, was nope. That's because you guys didn't even pick the phone up. You're like, well, I don't know if the Americans can do it. You didn't even pick up the phone and go, hey, we have a problem here. Maybe we should deal with this. No, you had your foreign affairs minister go sit on a stage in the middle of a trade negotiation with the American president, again, regardless of how you feel about it, compared to Bashar al-Assad and the North Korean dictator. Maybe not the best thing to do in the middle of a trade agreement while you're trying to negotiate asylum system reform. Like, this is incompetence. Like, I don't even, I've seen a lot of incompetence, but this is incompetence that has a human face, because the hundreds of millions of dollars that you've spent on the baloney that you're peddling is costing Canadian taxpayers. It's costing people who are trying to come into this country legally, because you're rediverting resources or redirecting resources to people who are abusing our system, and you're raising taxes on Canadians. Like, this is not how to manage an immigration system. And then the government, to add insult to injury, hires you. They hire you to be a communicator on the file. You don't have authority over any of these bureaucrats. You don't have the ability to bring a memorandum to cabinet or instruct the RCMP on this sort of thing. You're a glorified mouthpiece for the prime minister on this stuff. It's just, this has real implications that you guys have bungled so badly, that it's embarrassing. And you should be held to account in the fall for it. And we're just tired of it. This is a sham. This is a joke. So my question to you is this. Are you comfortable with your personal legacy? You've had a long career, Minister, breaking Canada's immigration system for you and the Liberal Party's political gain.
Thank you very much for the question. I'm very comfortable. The job I was given included taking steps to more efficiently and effectively manage the issue of irregular migration. And as I've already advised this committee,
I guess I'll take that as a yes, and I hope voters hold you account to that.
If you don't want the rest of the answer, Ms. Rempel, I'll defer to the chair.
I don't know.
We have about 25 seconds.
I just think the answer to that is yes. And I feel bad for you, Bill. I really do. I do. So I wish you the best after October. Thank you. I'm done.
Ms. Kwan.
Well, thank you very much, Mr. Chair, and thank you, Minister, and to your staff for being here today. I could do a rant, but I won't. I'm going to ask some questions instead. Jean-Luc Collet from the UNHCR said in April in an op-ed that he was assured by the government no one would be removed without a hearing. So that's a quote. So currently, the pre-removal risk assessment does not guarantee a hearing. So is the government planning on changing the pre-removal risk assessment process and expand it in use and scope to include a guarantee hearing process?
Yes. Yeah. Thank you very much for the question. The answer is essentially yes. What we intend is that for people who have not been determined to be not eligible to be referred to IRB, and because they have made a claim elsewhere, and this is what's in Article 16, because they've made a claim in another country that's deemed to be a safe country, they will be given an opportunity to have a pre-removal risk assessment, and that will be not just a paper exercise, but it'll actually be a hearing. They'll be afforded they'll have an opportunity to bring forward legal counsel. It will be heard, and they also get the benefit of judicial review at a federal court. And just to facilitate that, as included in these budget submissions is an increase in the number of federal judges by 3 in order to facilitate those hearings in a timely way. And once they've had that hearing, if it's determined that they are at risk, they will not be removed.
Okay, so you're saying that everyone will be guaranteed a hearing process. It will be conducted by judges through the federal court. Did I hear you correctly?
No, it would be conducted by officials. The officials that currently conduct the pre-removal risk assessments will still have that authority and responsibility, but it will be a hearing, a face-to-face hearing, not a paper exercise, in which an individual will have legal counsel.
Sorry, I'm going to interrupt for 1 minute.
Review.
Is it going to be a hearing or is it an interview? There's a substantive difference between a hearing versus that of an interview, because what you're talking about right now in that process is an interview with officials. Is that not correct?
Well, again, to give you an absolute clear answer, Paul, could you clarify exactly how the trial will work?
Yeah, I think hearing is the correct term, Mr. Chair. I would also state that at the hearing,
And sorry, and who are the officials who will be conducting these hearings? IRCC officials?
officials of IRCC.
And how are they trained to conduct these hearings?
Mr. Chair, these are individuals who are trained to make a determination about refugee status similar to the way the IRB members are trained. They're looking at the very same issues. They're looking at the Refugee Convention, and they're looking at the Convention Against Torture. So these are independent. They're not taking direction from any of us at the table. They are unfettered in their decision making, and they have years of experience.
So I'm going to
doing
ask this
work.
question: how many hearings will IRCC be funded for?
IRCC is funded to handle what we assess will be approximately, I'll check the figure exactly, Mr. Chair, but it's about 3,500 that we expect over the past couple of years, if this had have applied, would go through this new system. And we're funded for that in budget 2019.
So you're funded for 3,500. It's anticipated there'll be 50,000 applications that will come through. The minister just said that everyone will have access to this hearing.
No, but it's
so
important.
then you're short 15,000.
It's important to remember, Mr. Chair, that this is about individuals who've made a claim in another country, such as the U.S. It's not the complete cohort of 50,000. The vast majority of folks are going to the IRB.
We're not changing, just to be clear, we're not changing the process of the PRA. For those who have had an asylum claim that has been deemed to be ineligible. We're not changing it for those who have never made an asylum claim and are engaged in the removal process. We are adding for those individuals who have made a claim in a second country, a safe country, previously, who would not therefore be eligible under these rules for referral to IRB.
Okay.
They will have the benefit of this enhanced PRA.
Okay, so one of the key findings in the government's own 2016 review states, quote, one of the key findings from the previous evaluation was that the program they refer to is the pre-removal risk assessment program, had evolved from its original intent of providing a, quote, safety net for migrants requiring removal to providing failed asylum seekers one more step in the asylum system, evolving into a de facto appeal mechanism, end quote. Isn't that what you're doing in this process? Turning the pre-removal risk assessment process into basically a de facto appeal process.
We think it's very important for those individuals who perhaps, and just if we can personalize it, for those individuals who perhaps have been in the United States, had previously made a claim in the United States, who then come to Canada and attempt to make a second claim. They will not be eligible for referral to IRB. But before they can't be returned to the United States, they would be returned to their original source country. Before that takes place, they will now have the benefit of a pre-removal risk assessment, which is in fact a hearing, for which they have legal counsel, and which will be subject then to judicial review by a federal court. And that is in order to ensure that those individuals have protection. We don't want to remove somebody to a dangerous and risky situation.
Okay.
And so the pre-removal risk
so
assessment for those individuals, because of the circumstances under which they are not eligible for the IRB, we think it's an appropriate level of protection for them.
Okay, I won't debate the issue. I just want to get some answers for some of these questions. So as the pre-removal risk assessment is only available if you're being removed, right? You're at risk of being removed. So what happens to individuals who are from a country of origin that Canada has a temporary suspension removal or administrative deferral of removal with at this time? So that those are the countries that are deemed to be too unsafe to deport anyone to. What happens to them?
Yeah, but please go ahead, Paul.
So, Mr. Chair, they would remain in Canada just as if they had gone to the IRB and that referral was in place. So we're not going to remove anybody to a country.
Sorry, but they're not allowed to go to the IRB. If they've crossed over irregularly from the U.S., let's say, and they've already made a claim in the U.S., they are prevented under this bill to actually make an asylum claim here in Canada.
But if they go, I was trying to say that it's a comparable process. If they go through this new process and there is a removal order in place, and after the hearing is heard, the government would not remove somebody to a country where there was a removal.
So are you saying that those individuals will then be referred to this pre-removal risk assessment process, and then if it's determined that the country is not safe, which is apparently on the list of Canada's list of countries that's not safe, so why are you even referring to them to a hearing when you already know that that country is not safe? So isn't that a duplication of service? And then actually just on that point, we just got a report from the Auditor General telling us about the problems, significant problem within the government on duplication. You could have someone asking for...
You might get back to that in your final 3 minutes, Ms. Kwan.
Sorry?
We may get back to that in your final 3 minutes, but you've passed the 7:20 already.
Thank you.
Getting back over now to Mr. Sarai.
Minister, thank you for coming. And in your short tenure as minister in this, I've actually, after hearing today, pretty impressed that we've been able to reduce irregular border crossings, I believe, by 47% year over year. And this has been done without any special or separate legislation. In fact, it's been done by outreach and efficient enforcement and processing by your department and the department under IRCC. Can you tell me how many irregular, and for me, British Columbia is an important, obviously, constituency. Can you tell me how many irregular migrants have crossed over the Canada-U.S. Border into BC in subsequent months?
Yeah, so the calendar year to date for British Columbia is 67.
So 67 people have only crossed over.
Calendar year 2018, it was 479.
So that's sounds by rough numbers a 70-80% drop?
Yes.
Yes. And how will this legislation keep in curtailing an inflow of ineligible migration while protecting our international obligations and our compassionate and humanitarian history?
Thanks for the question. In a number of ways. The measure that we've just recently put in place, that those who've already made a claim in another country, in the United States, a safe country, cannot subsequently make a claim in Canada as well, will not be referred to IRB. That rule is already in place for those people who would cross at a regular point of entry. And so we're just ensuring that, and this is on the principle of fairness. People who are subject to rules, should they cross at a regular point of entry, we believe that people should be subject to similar rules should they cross at an irregular point of entry. And that's to remove any incentive or advantage to crossing irregularly. We're trying to encourage people to enter the country appropriately. You know, it's also been a fairly significant outreach to those communities where people are in fact not in need of protection, but perhaps are desiring to migrate to Canada for economic and reasons, a better life. And so a lot of it's been outreach as well to direct people to the appropriate way to make application to emigrate to Canada. And I think those efforts have proven successful as well. But we also recognize that we need to be able to respond to whatever presents itself at our borders. And so we've been building up the capacity because we want to be able to assure Canadians that, first of all, the safety and security of the country is being maintained. And secondly, and equally importantly, we're upholding our international obligations and the Canadian rule of law. I think Canadians expect a fair and compassionate system, but they also want it to be well managed. And you know, we're making sure we're right-sizing. And we're working very collaboratively with our partners in the United States and in other countries to make sure that, you know, proper intelligence is gathered, people take proactive steps to manage this situation, and for those who do come, that they are given access to a faster, and I didn't wish to characterize the system as currently fast enough. It's not. That's why we're making significant new investments in Budget 2019 to increase the capacity of IRB to conduct timely determinations of eligibility. And we're also working hard to make sure that those processes and systems are efficient so that CBSA can fulfill its responsibility for those who are determined not to be eligible. They can effect timely removals for those individuals.
And the office in the UN on refugees, what's their reaction been with respects to this legislation, proposed legislation?
Actually, we've had a very positive response. Of course, we consulted with them prior to the implementation of any measures. Their concern, and exactly the same concern was expressed to us by Amnesty International. They wanted to make sure that any individual, before they would be removed to a situation of potential risk, that they would have the benefit of a risk assessment, a pre-removal risk assessment, and that we would acknowledge the importance of the same decision in this country so that people would have opportunity to have legal counsel, a proper hearing, and the review at our federal courts. And so we were able to provide that assurance, and they have indicated strongly to us, UNHCR, not Amnesty, but UNHCR, that they believe that the measures we're putting in place uphold Canada's international obligations and are entirely consistent with, you know, principles of asylum primacy, and afford people, you know, what they describe is what they believe is a world-class asylum determination system in Canada.
And for the record, this applies to people that have claimed asylum in countries like the United States, Great Britain, Australia, and New Zealand. And if they've claimed it there, they cannot reclaim it here. And on the same token, they would not be returned back to a country that is considered by Canada at risk, where it would be unsafe to return them back. So those would be protected, as I think Ms. Kwan was
First of all,
saying.
the countries to which, if they've already made a claim, it's those countries with which we have an information sharing agreement,
Okay.
and that is the Five Eyes countries that you mentioned. And as an important part of this process is, even if a person was not eligible to be referred to IRB because they had made a claim in another one of those countries, they would still be given the benefit of a pre-removal risk assessment, and where there's a determination that they would be at risk, they will receive Canada's protection.
And do you have an idea on what this will affect in terms of volume? How much of our volume of refugee applications would this affect? Is it a 10%, 20%, 30%, or what cohort would
Of the
this be
40,000 people who entered Canada irregularly at our borders, approximately 3,000 of them, I understand, had previously made a claim in the United States.
Yeah, it's about a 3,500 level over a 2-year period.
And what's your understanding on the legalities of it? There was raised that it may not challenge, it may be subject to the Supreme Court ruling in Singh versus Regina. Has your department looked at it, and both ministries looked at it to see if this would withstand a charter challenge?
I believe it does. Of course, everything is subject to the potential of a challenge, but it is our strong belief that this is constitutional. It's consistent with previous court decisions, and it upholds our legal obligations and our obligations internationally.
Just 20 seconds, Mr. Sarai.
I'm fine. Thank you.
That's great. As we move to our next round of 5 minutes, I do recognize that the time belongs to the members and they can use it however they wish, but I hope that we can be respectful and try to keep the questions related to the legislation before us. Merci, Monsieur Paulus. Bienvenue. Vous êtes pas normalement membre de notre commission.
Welcome here, Mr. Paulus. You're not normally a member of this committee, but I understand that you have some questions to ask, and if they're in French, there is interpretation available. Go ahead. Thank you. Minister, ladies and gentlemen, we got the Auditor General's report, which is quite condemning, quite scathing when it comes to immigration. So when it comes to solving our problems administratively, Minister, you were appointed a little over a year ago. It's a new position. The government decided that in order to manage these problems, immigration wasn't doing a good job, public safety wasn't, so we're going to appoint a new minister for border security. How effective has your new role been?
Frankly, a little less than a year ago. The responsibilities I have been given, I've been working very closely with senior officials. I think we've made some significant progress. As I've already iterated to you, we've seen a significant decline in the number of people who've been presenting themselves irregularly since my appointment, and frankly, that had nothing to do with my appointment. It isn't directly as a result of some very effective measures that have been implemented by our officials and the work that they have done internationally, and it's very important to acknowledge that. We've also been brought forward a number of measures which we believe will continue to build upon the capacity in Budget 2018 and now subsequently in Budget 2019, increase and right-size the ability of IRB to do timely determinations of people's eligibility, and we've brought forward measures that I think remove some of the disadvantages and perhaps incentives that existed in the previous system that encourage people to cross irregularly.
OK, ça, Monsieur le Ministre, je vous arrête, Monsieur le Ministre, parce que là,
Minister, let me just stop you right there, because we're talking about people who want to come or who could be discouraged from coming. But I'm talking about the problems we're having currently. Over $1 billion will be invested in domestically, just at the federal level. Let's not talk about the provinces. But in what way will this bill and this funding solve the domestic problem? Because everyone's working in silos. There's no coordination. Immigration is working for its part, CBSA, and they're not even talking to each other. That could create problems. The backlog is already huge if people aren't talking to one another. Well, you're there now. You're in the middle. So how is this bill going to make things more effective?
Familiar with the Asylum Management Board that has been established that brings the senior officials of IRCC, CBSA, the RCMP, all departments who have a responsibility to manage the issue of the refugee system, including irregular migration, are those senior officials that was formed in 2018. They have significantly improved the collaboration and the horizontal integration of these services. And as well, I think you'll see reflected in Budget 2019 that we've identified where additional investments were required at IRCC, at IRB, at CBSA, at the RCMP, and in order to support the important work that they do to maintain the integrity of our borders and to manage in an efficient, fair way our asylum.
Au-delà de l'argent, on fait juste parler d'investir.
Besides money, you're just talking about investing money. Isn't there anything else that can be done to solve this problem? Because there's coordination, there are orders that are not being given, because over $1 billion is being invested currently with no results. And that's not, I'm not the one saying that. But let's leave that aside. Let's talk about security. In the Auditor General's report, there was talk about CBSA having problems screening people for security screening people at the border. There was
absolutely emphatically that there is no individuals with any serious criminality or security concerns were admitted into Canada. There have been a very small number with whom biometrics were not properly enrolled in databases. And John, just quickly, if you wanted to comment on any aspect of the work CBSA is doing on that.
Yeah, I think it's important not to conflate a biometrics enrollment in GCMS with a proper security check. So you can still do a check with U.S. and Canadian criminal databases with biographic information. We do that. We've gone through the files as a manual review and assured ourselves that that, in fact, was done. And the officers deal with the criminality as they would with anybody else that presents themselves that has any criminal issues.
Merci, Mr. Oweski, et continuons avec M. Ayoub.
Merci, Monsieur le Président. Merci.
Thank you, Mr. Chairman. Thank you, Minister. I'd like to begin by apologizing to the officials for the comments I've heard. I don't think they were appropriate because you're here, Minister, and your officials are working to improve the situation for all of Canada, and I'm certain of that. I'd like you to repeat to us, because you already said this, but there's some misunderstanding about the results. There's been a drop in the number of applications, a 47% drop in irregular applications. In the summer of 2017, that was a very busy summer in Quebec. What has changed with this new bill? What will be the effects of this new bill? And how can you be confident that this is going to improve things?
When the immediate influx occurred in Quebec, there was an excellent response at that time, but it was a reactive response. With the large surge of people that presented themselves at the border, particularly at the end of Roxham Road in Quebec. The impact was also in other places, such as Emerson, Manitoba, and on the Pacific Highway in BC. But our officials, I think, responded quite appropriately and have dedicated the resources and put in very effective processes, which I've reviewed very extensively, and I'm quite reassured by the excellent level of collaboration and the thoughtful way in which they have been managing this increase, which is being experienced around the world, but being exceptionally well managed, in my opinion, by our officials at the border. And the fruit of their labor is both, we've seen a significant reduction in those who are presenting themselves irregularly at our border. And just I'll give you another example. We heard earlier about BC. In Manitoba, in 2017, nearly 1,300 people crossed irregularly into Manitoba from the United States. Last year, that number was reduced to approximately 500. In the first 3 months of this year, that number is down in single digits. And so it's a direct result of some really good work that's been done by our officials and in collaboration with their partners in the United States and in other parts of the world that has affected this change. But at the same time, we recognize that timely determinations by IRB required significant new investments. And so we've been working with the new director of IRB to make sure that he has additional personnel to make those timely determinations, and the level of collaboration and innovation that has gone on between our officials through this this new management board that exists between our senior officials that oversee these processes, and a number of innovations. For example, there's an integrated claims assessment project that is now underway, which is bringing much greater efficiency to those processes. And as those people who would seek asylum in Canada, perhaps who may not be in need of our protection, I think as there becomes a greater awareness of the improved efficiencies and the more timely determination, and the certainty that you will be subject to removal if you are determined not to be at risk, those are also helping us reduce the number of people who would present themselves irregularly.
Dans la question que je vous posais, si jamais vous aviez les chiffres du...
If you have any figures for Quebec, I'd be interested in those. My question is about the fairness in the processing of applications between illegal or irregular applications and normal, proper applications. So it's important that these applications be processed fairly and that the rules be followed.
In the early part of this discussion about the large number of people that were presenting themselves and crossing our borders irregularly seeking asylum, there was a lot of suggestion that this was a security or safety risk, and I can assure you that it is not. Our officials go to exceptional lengths to ensure that there is no threat of criminality or national security. But there was also an issue of fairness. And I think for many Canadians, they were concerned that people who were presenting themselves irregularly perhaps were receiving some kind of an unfair advantage. And it's one of the reasons we worked really very hard, and we bring forward measures in this budget bill in order to reduce any incentive or advantage that those who might choose to cross irregularly would have over those who choose to cross at a regular point of entry. And it's simply an acknowledgement and a respect for Canadian sense of fairness. This system needs to be fair, it needs to be efficient, and it will always be compassionate.
Thank you very much, Minister. And with the last 4 seconds, I believe we can move now to a combination of Ms. Rempel sharing her time with Mr. McGuire, I believe. Ms. Rempel.
What percentage of the people who have entered Canada illegally from upstate New York since January 2017 and then subsequently claimed asylum would Division 16 of the BIA have applied to?
I believe for those who had made a previous claim in the United States, my understanding is that number is somewhere between 3,000 and 3,500. Is that correct?
So about less than 10%, like 5 or 6%.
That's for that particular provision.
Thank
for
you.
Those who have previously made a claim.
I just wanted to put that on the record. You didn't quite answer your colleague's question, who said, I think it was something effective, have you done any analysis to see if this would survive a Supreme Court challenge or a court challenge? You said you believe that. Was there analysis completed, and would you table that with the committee prior to the review?
Justice.
We've certainly worked with the Department of Justice on that analysis, and we have the charter analysis. Whether or not, Mr. Chair, Justice is okay with us tabling that before the committee, we'll certainly follow up through this question.
I would say it's a little material to this. If that analysis shows that it's not likely to survive a court challenge, which I don't think it will, is it your intention to use the notwithstanding clause to have it upheld?
I remain confident that it will, in fact, meet that challenge, and that's the advice we've received from Justice. But again, I wouldn't presume to speak for them. If we have an opportunity to table that opinion with the committee, we'll certainly try to endeavor to do so.
But do you expect court challenges on this?
In my experience, almost every area of law is subject to litigation. That's the nature of any new law. So it's certainly possible that
That's a
someone
yes.
may seek to challenge it, but I remain confident in its constitutionality.
Have you budgeted anything with regard to the fact that this most definitely will be litigated? How much is that anticipated to cost? And again, are you anticipating using the notwithstanding clause?
There is nothing in Budget 2019 that we presented that specifically speaks to that. We don't anticipate that it would require extraordinary resources to deal with such a challenge.
Thank you. Over to Mr. McGuire.
Thanks to my colleague, and thank you, Mr. Chair. I guess one of the things that I took upon myself last year was to put a letter to the public budget officer in regards to what it would cost for all of the illegal border crossers that we've had come into Canada over that period of time. The government had budgeted a couple $100 million for it all. It came back last November. They told us it was $1.1 billion. Now I see that you've come up with I think it's 1.18 in your in recommendation 2.28 here. Over 5 years to try and handle some of these processing, 40,000 asylum claims. There's a backlog of 71,000. Do you see this coming anywhere close to the cost required in being able to manage this, considering that this doesn't include any of an equal amount that the provinces have indicated that they're going to need to pay as well?
And we believe that the budget that we have submitted is the appropriate budget to adequately resource IRCC, IRB, CBSA, the RCMP, and other federal agencies that have a responsibility for this.
And you believe that that's going to do it when there's a 71,000 backlog already? You're going to do 50,000, and you've got claims. You're hoping, from what I understand in the report released today, that there's a hope that will catch up, allow them to catch up, because if there's fewer coming in this year, it'll allow for some of that backlog that's very heavy there, very public, to be caught up.
And in order to manage this properly, Mr. McGuire, we're doing two things. We're making significant effort to decrease the number of people that are crossing irregularly, and we've achieved, as I've already indicated to this committee, a significant level of success. And we are also significantly increasing the capacity of our agencies and departments.
Mr. Blair, it's a little late, as my
in
colleague
particular.
said earlier. It's a few months to an election time. Why didn't you start 2.5 years ago when this first became a problem?
We did, and you may not recall, but in budget 2018, we added $74 million, for example, to significantly increase the capacity of IRB to conduct hearings. That was, as I recall, discussed at this committee. I'm not sure whether or not you recall that.
That's my point, Mr. Blair. The $74 million is a drop in the bucket compared to what it is required by the provinces and even your federal departments to be able to manage the backlog that has come forward over the last few years. 2 years there was 40,000 illegal crossers.
There won't be time for an answer to that question, but maybe Madame Zaid will ask a similar something.
Thank you, Chair. Thanks, Minister, for coming today. I have many immigrants in my riding of Scarborough Centre, and you also have many immigrants here from neighbouring ridings. And they, like all Canadians, believe in the importance of a fair system of immigration for everyone. I know Canada is a welcoming country with strong support overall for immigration, and crucial to maintaining that public support is the perception that system is fair and just for everyone. So can you please ensure us that these changes being brought through Division 16 are protecting the integrity of our immigration system, but at the same time, we are also meeting Canada's international obligations and ensuring we are a place that welcomes those in genuine need of our protection.
Thank you very much, Mrs. Heath, for the question. I think it's an important one. I think maintaining public confidence, Canadians' confidence in their refugee protection system, I think is critical. We have worked very hard to make sure that it's adequately resourced to deal with the volumes that Canada and other countries in the world are currently experiencing. And we saw a fairly significant increase in the number of people that are seeking asylum. We also heard from many Canadians concerns about whether or not those who were crossing the border irregularly were being treated in the same way as those who chose to seek asylum here at a regular point of entry. And so we've examined all of the rules, and we worked very hard to make sure that we strike that balance, that we maintain fairness in the system, that there be no particular advantage to an individual who might choose to cross irregularly, but also acknowledging for people who are fleeing war and persecution and fear for their lives and the safety of their children, we are always going to be a country that is welcoming and receptive and of offering of protection to those individuals. We understand as well that the fairness in the system requires timely determination of whether or not a person is eligible for the protection of Canada. And so we know we needed to make significant new investments in IRB's capacity to do that. And at the same time, we will have to make sure that those systems are also efficiently conducted. And because some of those individuals are determined not to be eligible, they have to be subject to a timely removal. And that's done in a careful and compassionate way, but it's important that the system also reach a finality and to assure Canadians of its fairness. And I think we've achieved the right balance of success. I've had extensive conversations, as I've already indicated, with UNHCR and with Amnesty International and with others who want to ensure that Canada maintains a compassionate, welcoming approach for those who are truly in need of protection, and that we uphold our legal obligations. And I believe very sincerely that the measures that we propose in Budget 2019 and the bill before this committee, that we have achieved that balance and implemented measures which are thoughtful, reasonable, lawful, and appropriate for the circumstance.
You mentioned in your opening remarks that 24 million refugees are there globally, and 258 million migrants are on the move. So the refugees are either fleeing war zone areas, or they have to leave their countries because of natural disasters. So do you really think that the number of the irregular border crosses which we saw towards Canada, was it just because of a simple tweet?
Frankly, I personally believe that that's an absurdity. And one only has to read a newspaper to see what's going on in the world and to see how other countries in the world who are also like Canada, welcoming, compassionate, and safe places, that people from all over the world have sought refuge. There are real conflicts and real risks in many parts of the world. And Canada has a long and very proud history of being a place of welcome to those who are truly in need of our protection. And if we also reflect on the contribution that those people who have come seeking Canada's protection have made to building a great and strong and resilient country, I think it's a source of great pride for all of us. But to suggest that 250 million people all of a sudden got on the move because of a tweet is kind of silly. And to suggest that the global phenomenon of nearly 25 million true refugees in this country are influenced, just to put it in context, of that 25 million people who the United Nations Refugee Agency identifies as true refugees, less than 0.16% of those have actually sought refuge in Canada.
Thank you very much, Minister. And we have a final 3-minute round of questions from Ms. Kwan.
Thank you very much, Mr. Chair. Well, I just want to talk numbers then for a minute. You have a backlog of 71,000 cases. The IRB told us that they expect about 60,000 cases this year and 60,000 new claims next year. And so what the budget provides for is a funding of 40,700 this year and 50,000 next. So simple math basically tells you that you're actually going to run into Legacy 2.0. So the leftover problem that the Conservatives handed to you with Legacy 1.0, you will now actually have Legacy 2.0, even with your additional funding. So my question is, how will this really solve the problem? And then on the issue around creating the pre-removal risk removal assessment stream, right, into sort of shoveling 3,500 cases through that stream, aren't you actually just diverting the work from the IRB to IRCC to do exactly the same thing?
No, and to your second question, I would respectfully submit no, that it's not. The processes through IRB, all of the subsequent reviews and appeals and judicial review takes a fairly significant period of time. The pre-removal risk assessment notwithstanding a hearing with legal counsel and subject to judicial review, I believe can be done in a far more timely way. I also believe that individuals who realize they won't have access to the full determination of a second asylum claim if they've already claimed in another country would be encouraged and incentivized to remain in the existing country, which will help us reduce the numbers. I agree it takes time. We've had many discussions with IRB. It takes time to build up their capacity to address the numbers that are currently in the queue. But they are making real progress, and so it's increasing their capacity as part of our strategy, but also reducing the number of claims is also part of our strategy by making sure that people have a clear understanding of our immigration systems, of the law as it pertains to asylum claims in this country, and to make sure what we have discovered is that by being proactive, by going out and communicating more effectively and working with our international partners, we've been able to achieve a very significant reduction in the number of people presenting.
Well, thank you for that. But based on IRCC's own projection, the IRB's own projection with the number of cases that they anticipate for this year, next year, if you run through all of these numbers, you will still have a backlog for over 80,000 cases. So really, you're not solving a problem. Those 80,000 cases, even from the Auditor General's report, basically, and he was only projecting a 50,000 caseload increase each year, and they're projecting a 5-year process of having people lives who are going to be stuck in limbo. No, not much better, frankly. In fact, pretty well the same as what the Conservatives had handed over to you. And this is what this government is going to now do, and on the eve of an election, handing over to whoever assumes office after this. So,
thanks, Ms. Kwan. Do you have very quickly for the question? Your 3 minutes is up, but if the minister's prepared to stay and answer it, he can.
Well, I'll ask a very quick question. I asked the minister if I could have a sit down to go through this legislation with him on a private setting so that we're not limited by time to get the questions answered. And I was not granted that request. I wonder whether or not I can make that request now to the minister.
Yeah, of course. I'm not sure what the difficulty was in scheduling some time, but you and I have had an opportunity to speak previously on other matters. And if we can find a mutually convenient time, I'm happy to meet with you.
Tell me when, I'll be there.
Thank you very much, Minister. We'll maybe recess for 1 minute while we clear the table. And my understanding is that your officials are staying for the next hour. Thank you. We'll now have an opportunity to continue on with ministerial officials on the questioning we've just had with Minister Blair on Part 4, Division 16, the Budget Act for 2019. And I believe the first opportunity to ask questions of the officials is Mr. Sarai. Mr. Sarai?
Not going to be speaking. It's like straight to it. Okay. Thank you once again for being here and giving your time. I have my first question is actually it was something I perhaps wanted to ask the minister, but I'll ask you. There's a new authority to issue an order in council to stop processing TRVs. I think it's clause 304. Gives the governor and council the authority to issue orders regarding applications for temporary resident visas, work permits, study permits, if foreign governments are unreasonable or unreasonably refusing to issue or delay the issuance of travel documents. I'm just curious, is this a common practice? And if so, how many countries is this prevalent with? And do you think this tool would be essential to solve that problem?
Mr. Chair, I can say a few things on that. I do know that the United Kingdom follows a similar process. And the concept is a fairly straightforward one. To assist our colleagues at CBSA in receiving travel documents, the government feels that two things perhaps could be helpful. Number one, positive incentives to work with those countries on things like the integrity of their documents, the integrity of their passports, but also perhaps in certain cases to decide that the government should pause or stop the visa issuance for all nationals, a particular cohort of nationals. But that decision would be made, Mr. Chair, at that time, and specifically looking at the broad bilateral relationship, not just the visa issue and the removal issue.
But is there an epidemic right now? Is there certain countries that are giving us a problem in terms of giving travel documents that felt the need for this?
Perhaps more to CBSA.
Yeah, there are some, but it's a very dynamic environment, I would say, that you have to situate it in terms of the broader sort of bilateral relationship at any one point in time. And this would be just another useful tool for us to use. But I would emphasize Paul's point in terms of trying to have a positive relationship with these countries in that broad sort of sense, and recognize our interest in returning these people back and working with them to make that happen as smoothly as possible.
Okay, thank you. In terms of the new directions on determining if refugee claims are eligible to be referred to the IRB board, the first step when a refugee claim is received in Canada is an eligibility examination. It's the 3-day deadline prior to referral to IRB would be removed now. How much time do officers currently need to assess eligibility?
Well, certainly from our side, when they present themselves at a port of entry, it could take up to 8 hours to go through a claim. It kind of depends on the complexity, how big the family unit is, what we find during that process.
So what's the need for removing this 3 days? The point that they'll be done quicker, or they may be done longer, or they may take longer? I'm trying to figure out the intent of this change.
Well, I think it's really just so we don't get pressed to sort of artificially not have the time to do our processing properly. So when there's a period of larger volumes, that it allows us to maintain the integrity of the process without an artificial deadline hanging over our head.
Okay. And previously, how often would this happen where the 3 days would be exceeded?
Yeah, we can get those figures for you, Mr. Chair. It really happens during times of significant influx at the border. So if you go back to the summer of 2017, where there were a number of people coming in, there were a portion that were outside the eligibility period. I'm just looking here to see if it... we'll get the figure and share it with, I don't want to take your time.
Sure. As to, I asked this to the minister in terms of the clause 306 of C97 is to make an individual ineligible to make a refugee claim if he or she has made a refugee claim in another country, one of the Five Eyes countries that we have sharing agreements with. Individuals in this situation would be permitted to apply for a pre-removal risk assessment. If this provision were implemented, what do you foresee the effects this would have on the volume of pre-removal risk assessment applications received by IRB? I know currently the minister had said about 3,000 or 3,500 and as to the irregular, but would this also affect those that fly in, or perhaps those that potentially we can see in terms of, I think, the DECA deadline that's looming in the U.S., people who have made claims in the States that the States may otherwise deem ineligible for the U.S., but they have made claims there.
Yeah, I guess the best proxy we have, Mr. Chair, to figure out what's going to happen moving forward is looking back, and that's that 3,500 figure that the minister shared with the committee. A significant portion of those 3,500 would be irregular claimants. This applies not just to irregular claimants, as you know, but to all claimants coming in. So we're anticipating and planning for that 3,500 over about a 2-year period, but it's challenging prospectively to know exactly what that number could look like.
And how do you plan to deal with the inflow? If the inflow or capacity rises, is there measures to deal with this efficiently and quickly so it doesn't become a backlog on its own?
We're funded for the figures that we're assessing, so it's around that 3,500. But I think, Mr. Chair, much like we've done during the past couple of years, we would look at how to manage certain influxes as we've done at Roxham Road, and the president has realigned work, so we would look at how to do that. But we don't anticipate that kind of influx in this cohort.
And now, you had stated earlier, and it's not very clear in the in what's been available now, but in terms of doing a pre-risk PRA hearing, will transcripts be done as they are so that they're available for appeals? Will they have the right to a lawyer there? Will it be in person, or are these made simply by on a paper application?
Yeah, maybe just a word on the role of counsel, Mr. Chair, because I think that's part of your question. Counsel is allowed to assist the applicant in preparing for the hearing, to clarify questions, assist with responses, but also able at that hearing to help clarify or correct information that comes up during that hearing process.
Thank you, Mr. McKinnon. If somebody gets back, maybe you'll get an opportunity to finish the question. Mr. Tilson.
Yes, it seems to me that the three main bodies that are involved aren't talking to one another. And I say that because of the Auditor General's finding that the information management systems of the IRCC, the CBSA, and the IRB are largely incompatible. I wonder if any of you have any comments with respect to that. And if my assumption is correct, how's that going to be resolved?
Thank you, Mr. Chair. I'll maybe start off in terms of the question. So, one of the things that we put in place last year was a board called the Asylum Management Board, and this is a board that where the heads of the departments, Mr. Osowski here, myself, IRB, come together about every 6 weeks. And the purpose of that board is to discuss those issues where we have information sharing types of concerns, or we're putting new initiatives in place where we want to be connected collectively together, so that as we go forward, we in fact are talking both from person's perspective, but also from an IT perspective. And one of the things that the recent budget investments gave us was $36 million to invest in new IT. So one of the things that we've been challenged with is that we have very legacy type of systems from an IT perspective, and so they don't talk to each other. And going forward, what we want obviously is to be able to be connected in terms of information sharing from an electronic perspective as well. So we actually are using our board that we have now, where we meet regularly to talk about those issues, how we actually project manage this, and how we actually implement those systems, both from a communications perspective and from a technological perspective. So in fact, the systems are actually talking together.
How often do they meet?
Right now, we're meeting approximately every 6 weeks, but there's times where we may come together more frequently than that to address specific issues. So as an example, with the budget investments, we pulled together a board so that we could talk about how do we collectively implement these initiatives so that we do that without either being in each other's way, or collectively so that we actually are in lockstep and don't inadvertently go off online.
So that's your answer to the Auditor General's comment that you feel that this management committee is solving the issue.
That would be one example, but under the management committee, Mr. Chair, as well, we have an entire governance structure. So as an example, we have a number of Director General working groups who collectively work together on a number of the both policy and operational implementation issues. So we work with other government departments, such as Global Affairs, such as Public Safety, our counterparts in our CNP and CSIS, Public Services Canada, as an example, Shared Services, so that those collective groups are working together so that we actually impact the entire system in terms of both information sharing and communication, so that we actually can move the system forward in an integrated way.
I'd like to refer, Mr. Chairman, to Clause 301, and I'm going to quote it in a moment, but I'm wondering if any of you could comment why it was necessary to add Clause 301, which states, to maintain through the establishment of a fair and efficient procedures the integrity of the Canadian immigration system. So my question is, what prompted the addition of this clause?
I think, Mr. Chair, it just brings clarity as to the objective of these provisions, and it aligns with similar existing objectives in IRPA, and simply states that the purpose of this is to maintain the integrity of Canada's asylum system. So it's a contextual type.
It's what?
It's a contextual type statement that is consistent with other parts of IRPA.
So there wasn't something that was unfair or inefficient in the existing piece of legislation. It's just a curious piece of statement to make, but maybe you've answered it.
I think, Mr.
I won't
Chair,
push
that
it
would be
any
the answer.
further. Mr. Chairman, the Auditor General has specifically called out the fact that the asylum claim system is inadequately resourced. And I'm not one, nor is my party one, to advocate for increased government spending, but we do have legal and treaty obligations in determining who is or who is not a genuine refugee. And that requires an adequately resourced determination system. So my question is, what efforts has the government made to come up with a more flexible funding model that responds to changes in the number of applications year over year?
Thank you, Mr. Chair, for the question. So one of the things that we've begun working on right now with our colleagues at Finance and at Treasury Board is to actually develop that more consistent funding model to take into consideration the fluctuations that we see in the system, and how do we actually ensure that we have the resources available to us in a timely manner. Of course, we do things all the time, as Mr. McKinnon indicated earlier. When we see pressures in a certain area, we move resources around. We talk to each other about how we can address that. That's not a sustainable way to do business. So part of the conversations that we're having with our financial officials and Treasury Board is, how do we actually create that system that allows us to kind of be more fluid in terms of our resourcing. So we've begun those conversations, and we're looking at the things that impact us, such as spikes in asylum claims or impacts in terms of movements that we can develop some kind of a formula that will help us do that. That work is underway now, and we hope to have something here in the coming months.
You just have 20 seconds left there, Mr. Tilson.
No, I'll pass. Thank you.
Ms. Kwan.
Thank you very much. Just want to get back to the IRCC the stream that they will be undertaking of about 3,500 cases, the risk removal assessment process. How many cases do they handle now with IRCC?
Mr. Chair, we handle approximately 2,400 cases per year.
So you handle 2,400 now. You're expecting to have another 3,500 added to your caseload. Where are the resources coming from again to handle that?
through IRCC, Mr. Chair, we have an extremely robust, I would say, cadre of decision makers across Canada and overseas as well. So recruitment is happening from within IRCC, you know, people who have, you know, the experience, the expertise in making those difficult decisions.
So how many people would you add then to IRCC to be dedicated for this specific stream?
At the moment, Mr. Chair, I could not provide you with an exact answer, but we're looking actively at the different models, you know, what would be required, the training that would be required as well, you know, to ensure that these individuals make good decisions.
I thought that previously we were already told that they were already trained. So now you're saying that they need to be trained, you need to find the people, and you don't know how many people you're going to find to do this work.
At the moment, we have a cadre of individuals who are making decisions. In addition to that, you know, in order to answer the demand and the inventory that has been created, we are hiring extra people, and we will be providing these training to these individuals who will be hired and will make those decisions.
Okay, so you're looking to hire, you don't have them yet, and you don't know how many you'll hire to anticipate to deal with this 3,500 caseload. Okay, I'm going to park that for a minute. I want to actually ask some other questions. So I see that the government has added, aside from the U.S., which is the obvious place, but have added, you know, basically the 5 I countries to this list of people who won't be able to be eligible to make an application. Australia is amongst one of them. The UN have ruled that in 2016, Australia's indefinite detention of refugees on Nauru Island on secret security grounds was both arbitrary and illegal. Amnesty International, Human Rights Watch, and other groups have long spoken against this continuing practice. And in 2017, the courts in Australia ordered the government to pay over $70 million to refugees, asylum seekers who have suffered physical and mental injuries while being detained in Manus Island detention centers. The Global Legal Action Network and Stanford Law School's International Human Rights and Conflict Resolution Clinic to the International Criminal Court, arguing that the treatment of refugees on these islands facilities has reached the levels of crimes against humanity. So are crimes against humanity acceptable as long as we have an information sharing agreement with them?
Well, Mr. Chair, in that specific case, because those individuals would not have made a claim in Australia because they're not allowed to make a claim, they would go through the IRB process. Here in Canada, we would not put them through this process because this cohort is all based upon the fact that you've actually made a bona fide
So what
claim.
if they've actually made a claim, if they somehow made their way to the U.S. and made a claim in the U.S., you would be making them to go through the process, no?
Well, if they made a bona fide claim in the U.S., yes, but
No,
for your specific
even if
example,
they didn't make a bona fide claim, even if they just make a claim, by virtue of the fact that they made a claim in the U.S. under this system, under C-97, they'd be rejected.
Yeah, but in your previous example, if they attempted to make a claim in Australia, they would not be allowed to in that example, so they would not come through this cohort. If they were in the U.S. and made a claim, yes, they would apply to.
Yeah, so if let's say that they somehow left the Australia and then got into the U.S., made a claim there, and then cross over to Canada, they would be going through this process. So I'm illustrating this point as, you know, as real issues in terms of this process that the government has instituted and the potential flaws within it that puts people at risk.
Maybe, Mr. Chair, just to clarify a little bit, it is important to remember that when they come to Canada, we're assessing them under our international obligations. So it's different than, we're not sending them back to a country for adjudication. They're going through the PRA process here, and we're confident that meets our international obligations.
But then I'll just take that for a spin because if in that scenario that I highlighted, you are saying to the person, okay, we won't reject you. You will now go to IRCC and then be assessed under the PARC process. Like, isn't that the duplication of work when you already know that Australia has this history? And hence the point, actually, that's been raised with the Auditor General today to talk about duplication. The right hand doesn't know what the left hand is doing. You have people applying for an expedited process. In the meantime, they're still just being processed regularly. Turns out expedited process is not any faster than a regular process. And here you are setting up, another system to deal with this dedicated group of people, effectively, as far as I could tell, creating a duplication in process. And I'm not quite sure how efficient it would be. Maybe in numbers, it seems like, oh, gee, if we divert 3,500 cases to this other process, it will lessen the demand for the IRB. The IRB, even if by doing that, you still have over 40,000 cases before them, and to which they're not funded adequately to do the job. The whole point about the Auditor General's report today speaks to the inability of the government to ensure that the IRB has rapid access to resources to process claims. This really doesn't solve the problem. The lack of resources does not really solve the problem. I have another question that I would like to ask. I'm not sure if I missed it when I went to the bathroom, but you have a provision under this bill that would allow the government to bar the issuance of temporary visas to all citizens of a country if that country refuses to issue passports to some of its citizens. So effectively, you would punish a group of people from a particular nation if that government is refusing to issue passports to some of its citizens. So under what circumstances do you anticipate that this would be used? Like, why was this actually put in Bill C-97?
Just 25 seconds, but I do note that this has been answered to Mr. Sarai. But
well, I can take that. So I think this is just another tool for us to put in place, and other countries are doing this. United Kingdom does this, where they try and sort of in a positive way engage with the country to make sure they understand our interest in taking their people back.
So in other words, this is just basically a stick, is a threat to say that we're going to do this.
What I said earlier was...
Thank you. We'll move on to Ms. Said.
Okay.
Thank you, Chair. Thanks to the officials. What period did the AG study? It was from which year to which year, on which the report is based by the AG?
It was January 2015 to June 30th, 2018.
So since then, has the government made any investments or changes that directly respond to the Auditor General's finding and recommendations? So can you please explain what changes you have made or what resources have been invested beyond that period?
Well, I can start from our side, certainly. Yeah, so there was investments in budget 2018, certainly that we took advantage of to help us sort of adjust to this new posture that we needed to respond to, and then subsequently in budget 2019. So there has been a continuous sort of evolution throughout the period that the AG examined and since the AG study ended, where we've been looking at investments to increase our efficiency in terms of how we process people both before they arrive, in terms of the interdiction work that we do with our U.S. counterparts, when they arrive, and after the after process, including the IRB and subsequent removal, should they be found not in need of protection.
And Mr. Chair, I would just add to that the investments that we've seen are supportive of those kind of three pillars where we're focusing our attention on the issue in terms of increasing capacity to be able to respond to the volumes, being more efficient, working collectively together more closely, and being more efficient in our processes and deterrence. So in various pockets, we see investment across the various departments. So as an example, IRCC, approximately $280 million, IRB, approximately $208 million. These are monies that's invested to help us increase in terms of our capacity and efficiency. And they include things like ramping up with new resources to actually be able to respond to the volume of claims that we have. And at the same time, putting in things in place, such as structures I spoke about earlier in terms of our Asylum Management Board, working together more effectively across the broader spectrum.
Now, if someone coming through the irregular border, they have done a claim, so a pro-assessment would be done by the officials of the IRCC. So is there any training program in place for those officers who would be doing the hearings?
Thank you very much, Mr. Chair, for the question. I think, I have to say I'm very proud of the work that has been done by colleagues at RCMP and CBSA and also at RCC at making sure that, we have well-managed migration flows in respect to irregular migrants. And the work that has been done has addressed, specifically that. We wanted the process, to be fair. We wanted to process as well, to be, I would say, recognizing the fact that it's not illegal to claim asylum in Canada, and making sure that these people are treated in a fair and human manner. And people are being processed in an extremely, I would say, efficient fashion. You know, for example, they receive interim federal health within a few days. They also receive work permits because we want these individuals to access the labor market very quickly. And it is done so, you know, in a very much an integrated fashion. And that's why last year we had a pilot called the Integrated Claim Asylum, the Integrated Claim Analysis Center, by which, you know, we were coming together, you know, colleagues from CBSA, colleagues from the RB, and colleagues from IRCC, at looking at how to best perform, you know, the process in order to make sure that the process is fast and efficient.
What is the difference between the hearing process at the IRB and the PRAV? Can you please explain a little how these two processes are different?
Yeah. You want to take that, Doug?
If you can share your time with Mr. DeCoursey.
Yes, yeah.
Sure. I mean, the Refugee Protection Division is a quasi-judicial tribunal, so it's kind of like a court setting if you want. And so if the minister's delegate intervenes, then it becomes adversarial. In a pre-removal risk assessment context, it's an IRCC official that reviews the application, and in the case where there's a hearing, then would interview through that hearing the applicant.
I'll share my time.
I might just add, Mr. Chairman, just to remember that they both look at the same issues to determine refugee determination. So the Refugee Convention and the Convention Against Torture. So they're looking at the same standard.
Do I have time?
You can continue for another minute and a half, Ms. A, because I believe Mr. DeCoursey has access to Mr. Taber's time.
One question for the CBSA officials. I believe in the past there has been some confusion regarding the security screening that is applied to asylum seekers. So could you please describe the security process, what that happens following a border crossing, and the security process that happens once a claim is found eligible to be heard?
Sure, certainly. So when somebody shows up at a port of entry, certainly for all refugee claimants, we conduct a series of processes using both biographic and biometric information. So we do criminality checks with CPIC and NCICC, which is the U.S. criminal information system. And we would share biometric information with our partners to see if they'd had claims in other countries. And there's an interview where we gather all of that information and make sure that we're dealing with all of the inadmissibility issues first, and then we would get into the eligibility aspect. So they have to, first of all, be admissible to Canada, and then we would deal with the eligibility for claiming asylum. Then, subsequent to that process, when they finally have their hearing with the Immigration Refugee Board, we do a more in-depth screening process. That's looking more at national security threats, organized crime things that we would do, checking other databases and working with our national security partners, specifically CSIS.
Okay, thank you.
Thank you, Ms. Saeed. We're now moving on to 5-minute rounds, beginning with Mr. McGuire.
Thank you, Mr. Chair. I guess one of the things that I was wondering from the CBSA as well is if we reviewed the did the CBSA even look at or review the legislation it would take to close the loophole for the anchor relatives arriving at a port of entry?
Referring to the Safe Third Country Agreement?
Yeah, and
well, we've certainly been participating in the conversations with U.S. Officials along with our colleagues from IRCC and under the minister's leadership. So yes, we've concerned.
And have you had any results of that?
We're still having fruitful discussions, but it's a process and it's ongoing, and there's a lot of goodwill, but it's situated in a larger context of the bilateral relationship, so it takes some time.
So what process is actually taking place? Is it discussions with equal departments in the U.S.?
Yes. In fact, I was down in the United States a couple of weeks ago, and I had discussions with Homeland Security about this, and they've expressed a lot of goodwill to looking at the matter, and it's just.
So do you think that solutions to that then should become part of Division 16?
I think that's a separate treaty that we have with the United States, and I think that would be separate from any legislative frame that we would establish through this process.
Just wondering as well, just as an example, if a person was to cross person in Canada was to cross the U.S. border between border crossings, between ports of entry, how would they be treated then if they sought asylum in the United States? How would they be treated under the safe third state agreement that we have?
So if they're showing up between a port of entry, are you talking about under the new proposed legislation or currently?
No, just...
So currently, if they show up in between a port of entry, we would...
In the United States.
In the United States, and they'd already started a claim process in the United States, they would still be able to initiate their claim here. Is that correct, Jennifer?
That's correct.
But what would the Americans do with them then?
In terms of...
Once like a person in Canada crosses into the United States.
Oh, if a person in Canada crosses into the United States.
Yes, that's the question I had.
Oh, okay, sorry.
Sorry.
So Mr. Chair, they would have access to the U.S. asylum system. They cannot send those individuals back to Canada because the treaty works both ways. So if they went into the U.S. at a port of entry, an official port of entry,
of course,
they would of course be returned to Canada.
Mr. Chair, the postponed hearings in this Auditor General's report that was put out here is that 65% of the hearings were postponed at least once before a decision was made. And every time we postpone it, it seems it adds a lot of time. Usually about 5 months, an average of 5 months the Auditor General found with versus cases with no postponements. And about a quarter of the claims were postponed multiple times. Adding at least 8 months to the delay, 25% of the claims. And that wouldn't be so bad, I suppose, but it appears as if, from what they're saying, is that some of the postponed claims actually had new claims being dealt with before the postponed ones were even dealt with. And it looks like a very high percentage of that. Can you just elaborate on why that would be? What process wasn't followed there to allow that to happen, I guess is the best way of putting it.
So I can't comment in details around how the scheduling and the postponements are taking place, but cases are postponed because of multiple reasons. It could be the security screening is not ready for the hearing to take place. It could be for an actual justice and fairness matter. So whether it's the applicant themselves, the claimant themselves, or their counsels that are not able to come to that hearing, or for operational internal reasons if the decision maker at the IRB is sick or unavailable. So then the IRB then proceeds with postponing, and then it's up to them as to how they schedule this in light of all the other claims that they have scheduled.
Yeah, so a lot of those were from what I understand, the postponements were sort of administrative issues that, according to the Auditor General's report at least, that the administrative issues that were within the government's control. And if you look at the board's scheduling practices, it says the postponed hearings should be rescheduled within 10 days, but only 10% of them were. What's being done to improve that?
Thank you, Mr. Chair. Maybe I'll just add a couple of pieces to Andre's comment. So one of the things that we've established in terms of our asylum management board is actually a specific conversation topic to look at what we call pain points. What kinds of things are actually clogging up the system or blocking the system, and then peeling those back to determine where are those root causes. So things like if say there's a delay in security clearances, why is that? Is it a information sharing piece, or is it in fact because it's with another department? As an example,
Thank
are there
you,
things
Ms.
that
McDonald.
we are?
Hopefully, we can get some more examples in the next set of questions. Moving to Mr. Ayoub for 5 minutes.
Merci. Oui. Alors,
Thank you. I'll go straight to the issue of the new orders. When an application is made in Canada, the first step is to determine whether the application is admissible, is in order, the refugee claim. And it will be now required to have that analysis done within 3 days. So how will the new procedure, what's the point of that 3-day deadline? And how will this ensure that people are treated fairly? Thank you. What's being taken out of the Act with this bill is that the application it's automatically considered to be in order or admissible, even if it hasn't been assessed by a CBSA or IRCC official. So it's a very short turnaround. It can be a few hours in one case or a few days, depending on how the application is made. But if there's an influx of migrants at the border, we want to give ourselves the ability and the time for our officials to determine whether those claims are in order instead of referring them automatically to the IRB. I see. So this would be for situations where there was a sudden increase, a sudden spike. Is that the logic behind that? Yes, that's right. It would give our officials more time to determine admissibility to Canada and whether or not the refugee claim is in order. How often are these applications rejected before being automatically referred on? According to our statistics, since January 2017, there were about 23,400 applications automatically referred to the IRB without our officials having an opportunity to finalize their assessment. Of course, they continue after they've been referred, and there were about 25 cases where the referral had to be yanked back, if you will, from the IRB. And Mr. Chairman, I'd like to add that it's very important to recognize that IRCC commits to treating those people quickly and effectively because it's to our advantage to be able to locate those people, to see that they have access to health care or work permits so that they can get to work as quickly as possible. Thank you for that clarification. Under Section 306, when a person has already made an application in other recognized countries, the 5 other recognized countries, if they apply in Canada, that application will be rejected. Do you have any idea how many applications would be rejected under this provision, just based by cases that you've already had before you? No, we don't have that information. The information we do have, well, that provision is intended as a deterrent. We hope that with that provision, people will carry on, see their applications through in the countries where they originally made them, and see what the decision is in those places. If this were applied in 2017, 2018, it would have applied to about 3,200 people, between 3,200 and 3,400 people who had multiple refugee claims. And 75% of those were irregular entries. Most of those people are still in the backlog before the IRB. And there's around 100 of those people who applied for asylum in Canada, then went to the US and applied, and then came back to Canada. About 150 people applied at the port of entry, and they were returned to the United States under the Safe Third Country Agreement, and they decided to come back to Canada, but this time irregularly. And it's mostly Haitians that we're talking about in that case. And it's a relatively low number, but most of those cases are still pending. When people come in and their applications rejected, do they end up having their file examined in some way, shape, or form so that they're not removed with no assessment at all? Unfortunately, Mr. Ayub, we don't have enough time to get an answer to that question, but perhaps if someone else wanted to ask the same question, we could get an answer then. Mr. Tilson.
The question I have, I'd just like you to comment a little bit more on it, and that has to do with Division 16 amends the Immigration and Refugee Protection Act to prevent asylum claims in Canada if a claimant has been rejected in certain other countries with whom which we have information sharing agreements. I expect that witnesses that are going to be appearing before us in subsequent after you, that's the area that they're most concerned with. And I wonder if you can help us as to the rationale behind all of that, because I can just anticipate, listening to what has been said in the media and elsewhere, that issue is not going to be accepted by a large number of people. Mr. McKinnon, do you have any thoughts?
I can offer a couple of thoughts, Mr. Chair. I guess the first thought would be that we are confident that this meets our international obligations, albeit it's a different process than going through the IRB. As I've said on a couple of occasions, it makes the determination based upon the same standards and thresholds as the IRB. My second and final point, respectful of your time, would be that, in some sense, we're not breaking brand new ground here. We have situations where certain claimants who come into Canada do not have access to the IRB, and they go directly to a pre-removal risk assessment. So I'll just give you a couple of examples. We have 5 or 6 that I can leave with you, Mr. Chair, if it's helpful. So somebody who's already made a previous asylum claim in Canada, including those whose claim was withdrawn or abandoned, if they already have protection in a third country, so they're already granted asylum, but they show up in Canada and make an asylum claim, they go directly to the pre-removal risk assessment. Or if they're inadmissible for security, violating human or international rights, serious criminality, or organized crime, they do not go directly to the IRB for the Refugee Protection Division, the Refugee Appeal Division, the federal court, and then the PRA. In those examples I've given you, Mr. Chair, they go directly to the pre-removal risk assessment, which is a comparable process to what we're suggesting for this cohort. But the main point I would leave with you is that they are looked at under that international obligations to Canada, which is critical. The government does not want to send anybody back to persecution.
I would expect it's the exact opposite, that this is a move to reject asylum claims.
To reject asylum claims, Mr. Chair?
Mm-hmm.
Well, it's a move, Mr. Chair, to recognize that you should make your claim for asylum in that first safe country you enter.
Yes.
And my colleague shared some figures of people claiming in the U.S., coming to Canada claiming, being sent back to the U.S. under Safe Third, coming back to Canada through Roxham Road. In that case, we think it's best for the overall system if that individual makes the claim in that first safe country.
I may be asking a political question, but we'll see what the chairman does. We'll test him out. It's time to be tested. Are you aware of any discussions that have gone on with the Americans on this topic?
Well, I'm aware, Mr. Chair, because
are you able
officials,
to talk to us? Are you able to talk to us about it?
Talk to you about it in that might be a political question, I think, Mr. Chair. I'm not sure exactly.
I'm hoping you'd say
question.
It wouldn't be.
I mean, we as officials, as senior officials, we speak to our American colleagues all the time. So we.
But this is a concern that's going to be raised in this committee, and so I'm interested as to what the comments that you've had with the Americans.
I can only speak to my conversations, Mr. Chair. They've been of a general sense in which we give them a briefing on what the government is putting in the BIA, and we'll keep them up to date as this committee deliberates on where you take this proposed legislation. So it's very much of a briefing type discussion, Mr. Chair.
How have they responded?
I think it's fair to say, Mr. Chair, that they've responded positively in that they haven't raised concerns with anything that's in the BIA.
So, does the government have a plan to implement the Auditor General's recommendations on developing a more flexible funding model? I think, Ms. MacDonald, you referred to that.
Mr. Tilson, that's a wonderful question, but I'm afraid that we've reached our 5 minutes, and I'll be moving on now to Mr. DeCourcy.
Thank you.
Thanks very much, Mr. Chair. Mr. McKinnon, I wanted to give you a chance to answer a question I don't think you had the opportunity to answer properly earlier, which is the distinct difference between a refugee claimant who would have been barred the ability to ask for asylum in Australia, that made their way to the U.S. where they claimed asylum and then came to Canada, versus asylum claimant B, who was in Australia, unable to make a claim, and then came to Canada. Could you please answer that so we can get that on record, the distinct difference in the way that Division 16 would treat those two different applicants?
So just to the member's previous question, Mr. Chair, that in the example of folks in Australia who are going off to one of the two islands, they don't actually make a claim in Australia. They're not, I think the term I used was allowed to make a claim in Australia. So if they ended up wending their way to Canada somehow and made a claim here in Canada, they would get access to the IRB. They would not be part of this cohort because the key element here is that you have made a claim in one of those other countries for which we share information, and in essence, those individuals did not make such claim.
Okay, thank you. I wonder if folks at the table could talk in maybe more specifics about the significant amount of activity that has taken place, not in result of the AG's report, but coming out of the Yates report that was tabled a number of years ago to help build up the capacity of the departments involved, of the Immigration and Refugee Board, that Yates report clearly articulated was under-resourced and unable to deal with the demand on the system. Can we maybe talk about the laundry list of activities that have increased efficiency and resources for the Immigration and Refugee Board to help process the demands on our asylum system?
I can offer a couple of comments, and maybe others want to jump in. Certainly there's been broad investments, Mr. Chair, across all agencies, just simply to keep up with capacity. So those investments have been made both in the 2018 budget and significantly over the $1 billion in this 2019 budget. There's been investments in intelligence gathering and intelligence analysis, looking at these cohorts broadly and determining how we can work with other countries, for example, on the issuance of visas. A lot of significant work done, Mr. Chair, with our colleagues in the operations branch, working with U.S. officials and officials in other countries on the issuance of U.S. visas to those citizens, because as you know, a big percentage of people arriving primarily in Quebec actually have a valid U.S. visa. We've had significant outreach by members of Parliament and others, in particular right after the Haitian arrivals, which at least in part we think helped with those numbers of irregular arrivals. And just respectful of time, I might keep it there, but I don't know if John has other comments too.
Well, I would simply add that the essence of the Yates report was that we needed to look at it as a system, and that we needed to make sure that we were better coordinated than we currently were. So that's something that we took to heart, and we've referred to our Asylum Systems Management Board a couple of times now, and that's the mechanism that we use to sort of work together without impinging upon the independent quasi-judicial findings and processes that the IRB has. So there's still a lot of stuff that we can do to make sure that the scheduling is done properly and how we sort of prioritize our work, but it doesn't impede or infringe on their independence in making decisions.
Could we talk maybe a little bit, it might be helpful for people at this table to understand how the IRB is better triaging claims for asylum as a way to make the system more efficient and ensure there's finality, fairness in a fast manner?
Very briefly, please.
No, I mean, thank you for your question. And I just want to point out, Mr. Chair, I've talked about the Integrated Claim Analysis Center, the pilot we had in Montreal. We are ramping up to have a similar pilot center in Toronto where most of the claims are being presented. And it's really, working at the claims, according to three phases, if I may, really looking at how we can stream some of those claims, being more efficient in their process, looking at the staffing, the hiring, the training that we've talked about, really looking at IT solutions for the different entities, participating in this center, IRB, CBSA, IRCC, and really having a more centralized, I would say, registry that would assist, in the process of the claims.
Merci, Monsieur Dumas. Mrs. Kwan, and perhaps you can go for 4 minutes if you would like, Ms. Kwan, and Mr. McGuire and I will each take a minute at the end.
Well, thank you very much. It's very kind. Well, I just want to go back to the Australia example for 1 minute, because I think that my point is this. For the people who come from Australia, somehow got into the United States to make a claim, and then they have to cross over, and then if they then make the decision to cross to Canada, they will be subject to the IRCC process. That is the point. They will not go to the IRB. So I want to say that very clearly. Now, if the IRCC's pre-removal risk assessment process provides the same standards and threshold as the IRB, then I have to ask the question, why set up another process? Why not just go through the IRB if it's in fact effectively the same? Because that's what I'm hearing from the government, from the minister, and from officials to say, don't worry, they will actually have due process afforded to them. Then why set up a different process if all things are being equal and they would just have to go through the process in any event?
I could offer a couple of comments, perhaps, Mr. Chair. I think the minister referred to the term deterrence, that part of this is also about potential deterrence in the system, that people will not make a claim in one of these countries and then come to Canada and make another claim.
So in essence, this is a process to send a message to people, potentially putting people at risk, to say, don't bother coming if you've already made a claim, even though you may very well have a valid claim, even though under the International Refugee Convention that you may very well have a valid claim. We're just saying to you, don't come anyway. And then all that we're talking about is an impact of 3,500 claims, to which is what the government's projecting. So 6 months to an election, the government wants to make a political statement to people to say, don't come and make a claim, really aligning themselves to the Conservatives to say to the refugee claimants, don't come to Canada to make a claim. Because in essence, that's what I'm learning now in this process. And I get it, this is political, so this is not directed at the officials, directed to the government, right? I wish the minister was here to hear this, because in essence, we're playing with fire and with people's lives just to send a message. And then at what risk? People who actually have a valid claim and will have nowhere to go. Will have nowhere to go, and then they'll be subject to this situation. That's what we're talking about. And to me, I find it astounding. We will have other witnesses who will come forward who will talk about the risks that people are in, the United States being one of them. And I know the government and UNHCR will say that they're a safe country, but there are a whole lot of other experts who say that they're not. And then, in fact, Amnesty International brought an expert that we had a breakfast reception for all the parties and senators. And the experts from the Americas actually told us that, in fact, people there are faced with the worst violence in the globe, sexual violence and gang violence. And those individuals seeking asylum in the United States would be rejected out of hand because the Trump administration has made a declaration that they will no longer accept those claims. Those individuals are being forced to seek asylum somewhere else. Children as young as 7 to 9 are being recruited by gangs. And they were negotiating. The workers there were trying to negotiate with the gang people. What are they trying to negotiate? Please don't recruit the children until they're 13. That's what they're negotiating. That's why people cross over irregularly, because they are absolutely at risk. And what is Canada doing? We're going to throw up as many barriers as we can to say to people, please don't come to Canada, just so that we can reduce our numbers. That is the political game that's being played, really catering to the Conservatives and the alt-right in their move to try to close Canada's border in that move. And frankly, I do find it shocking, Mr. Chair. And yes, this is my 4 minutes, so I'm going to use these 4 minutes accordingly.
That was it? That was it, your 4 minutes?
It's unbelievable that we have now arrived at this stage.
Thank you very much, Ms. Kwan. Mr. McGuire, a simple question or a minute, whichever comes first.
Well, I just wanted to make the point earlier about when I was raising the issue of postponed hearings, 10 days, it's a concern that of people through the whole process that the amount that were postponed were actually jumped the queue by new ones that were coming in got ahead of them, leaving the postpones to be postponed even longer and longer. And I think that was a point that needed to be made. And I think that we could read the conclusions from the report with the delays and that sort of thing. And I was going to read it in, but I won't bother reading the conclusion into it, Mr. Chair. I think it's we're here to say that, in other words, it's not the bureaucracy's fault, I don't believe, that all of these things have folded out to be such long wait times and backlogs and everything else. It's just the fact that the government didn't give them the resources, or the departments the flexibility or the resources to shorten the backlogs in a timely manner. Thank you.
Thank you. And maybe if I just have one question, Ms. McDonald, the amount that's allocated in the budget for the delivery of this program, is it the amount that was recommended by your department, or is it a lesser amount?
It was the option that we did put forward for our government, and taking into consideration all the various factors that we were dealing with across the system.
Okay, thank you very much. We will recess for people to grab themselves a little dinner and recommence at the scheduled meeting time of 5:30. Thank you. Coming to this third round of the 100.
Voici la troisième partie de cette réunion de notre comité de citoyenneté et d'immigration. Nous venons de finir de rencontrer le ministre Blair et ses représentants, les représentants du ministère. Je remercie le professeur du Royal Canadian College et Jean-Nicolas Bouzet, qu'on voit souvent à notre comité, qui vient du Haut Commissariat aux réfugiés des Nations Unies. Monsieur Leprecht, j'aimerais commencer par vous, si vous voulez bien. Vous avez 7 minutes.
Thank you for inviting me. It would be a pleasure to answer your questions in both official languages.
Text and then give us sort of a sense of where we stand with sort of the current bill and some of the things that I think could be remedied there in a broader sort of way forward. So, I mean, the context has to be clear. Sort of internationally, there's a whole series of pressure, everything from population growth of another 3 billion people in the next 4 decades, to climate change, to social economic disruptions, civil religious strife, whatnot. That's going to put general climate change, that's going to put general continuous pressure on with regards to migration, and in particular issues of war and civil war, in particular civil war-like circumstances, as in some countries in South America. So in that sense, on the demand side, we can expect demand to remain the same or more likely to intensify. Then in terms of U.S. cooperation, so cooperation with the U.S. has been absolutely critical to maintaining the integrity of the system, everything from enhanced travel authorizations, biometric travel documents, intelligence exchange. And I just cite as one example that the cooperation with the U.S. authorities between mid-2017 and mid-2018 has reduced the flow of people across the border, irregular travelers, crossers, from 87 to 42. So it shows that demonizing our neighbor or calling into question the rule of law, circumstances, or integrity in our neighbor is strategic folly that, given the changes that we've made, it's in terms of making it more difficult to come to Canada by air for people who might otherwise be inadmissible, we will continue to expect greater pressure along the land border, and so cooperation, obviously, since we only have one bilateral partner on the land border, is going to remain integral. And then there's sort of supply side issues that were already mentioned by the Auditor General and others with regards to, and Neil Yates' report on the system. I also, in terms of context, I think need to point out that there's a social contract with regards to immigration in Canada, and it has 3 cornerstones. One is a well-administered migration policy around rules, principles, a principle approach, rule of law, that
that preserves the integrity and the security of Canada's borders. The second component is the successful economic and political socialization and integration of migrants into Canadian society. And the third is that immigration is of collective benefit to Canadian society and to Canadian prosperity overall. And it's those three components that are integral to safeguarding the integrity, the sustainability, and the legitimacy of the immigration system. And I would say that the Auditor General's report, as well as Neil Yates's report and others, point to that there's questions by Canadians and others around how well administered the system is. There's questions about being able to control borders in order to ensure a principled approach to migration. There's challenges around socialization and integration of migrants. I mean, we have at 1% of our population now in a legal immigration rate, compounded by a surge in refugee claimants. There are serious challenges around whether the premise of the last over 100 years in terms of immigration and socialization of migrants is going to continue to obtain within our society. And I think there's also some question about whether we'll be able to sustain the collective benefits. So what's the broader problem? That people are taking advantage of the right to claim asylum without meeting the criteria for eligibility. So the challenge then is to make Canada's refugee policies more timely and effective in distinguishing between persons who are genuinely in need of protection within the scope of Canada's international agreements from aspiring economic migrants who are seeking to exploit loopholes in Canada's border management system. And so to that effect, we have had and we've been observing a trend towards what I might call a libertarian approach to borders that is essentially facilitated by the ease of transportation, communication, broad communication strategies, mis and disinformation through social media and otherwise in terms of accessibility to Canada and whatnot, and that then facilitated on a global scale by systematic human smuggling that is well documented and amounts to some $10 billion a year. So by not ensuring that we have an integral system, we are also implicitly aiding and abetting the global human smuggling industry. So I also want to dispel the idea that somehow we can wait out the current political executive in the US. The phenomenon we're seeing might have been exacerbated by some decisions made by the Trump administration, but we can demonstrate empirically that it long precedes the advent of the Trump administration. So it will persist beyond the Trump administration. And so we will need to find a sustainable approach to this. By way of example, 2/3 of the people who cross irregularly...
Excuse me, Mr. Leutrecht, you're speaking fast and it makes it difficult for the interpreters to...
For the interpreter, keep up. I'll slow down. I have this problem regularly before committee, so I'll slow down. I make them sweat. Sorry. So the single largest group of migrants to Canada in terms of irregular entrance has actually been Nigerians who entered the United States on visitor visas. We also have the same documented phenomenon with regards to Saudi nationals. I quote those in particular because that is open source information. And that is, for instance, where cooperation with U.S. authorities is integral, given that that is the mainstay of about 2/3 of the people who are crossing irregularly. It is not individuals who are seeking to escape decisions with regards to temporary protected status, as some people have suggested. So it's important to maintain effective checks and balances, to maintain access to our asylum system for people in need of protection, while limiting actual and prospective abuses to the system. And so I point here in the legislation in particular to Section 306. I think that with my colleague Jeffrey Hale, with him I co-authored the submission, that an absolute ban on sequential applications may be an excessive response to a valid concern. And for reasons that we don't have time to get into, but different administrative processes and whatnot, we will suggest to limit the proposed exclusion to eligibility for refugees to a limited period, perhaps to 3 years from the date on which previous claims in such countries with which we have agreements have been finalized. With regards to Section 304, it makes sense the enforcement of reciprocity in the application of national immigration laws. The way that section is worded leaves lots of room for interpretation, and I have lots of concerns around the ambiguities that leaves with regards to the minister that would need to be clarified. In general, we strongly support the measures in the current budget, in particular given that it's always been difficult for governments to anticipate and manage all the trade-offs associated with policy decisions in general, in particular with regards to migration. I would like to close on the way forward. The way forward has to be restoring Section 41 of the Immigration and Refugee Protection Act, a regulation that's known as the so-called direct back provision. And that provision allows persons at significant risk to apply for refugee protection status from within the United States if they are not otherwise covered by provisions of the SCTA. Such measures would provide a safety valve in case of changes to U.S. temporary protected status provisions likely to create significant risks of another surge in irregular migration. However, a necessary condition of reinstating Section 41 would be to include amendments within the revised STCA providing for a standstill in prospective U.S. deportation proceedings for any person awaiting a Canadian refugee protection hearing under these provisions, and implementation of such measures would require safeguards to clarify the categories of persons at risk subject to such provisions to preserve the benefits provided by the STCA in providing effective triage of claimants from third countries.
Thanks, Mr. Leuprecht. You've managed to squeeze that in, but if you have that particular recommendation in writing, we can table that.
It's in the submission. I think it just hasn't had time to get translated because the request came on rather short fuse for me to appear.
Thank you. Ms. Nasso.
Thank you for having me. It's an honor to be here and to be part of such an important conversation. Today I'm here representing the Yazidi community in Canada and to talk about the importance of family reunification. We are thankful to the Canadian government for extending the one-year window of opportunity. This has given hope to many families who have found out that family members who have escaped ISIS now have an opportunity to reunite once again. We are receiving news of family members escaping frequently, and to know this is that this barrier is no longer an issue is key in reuniting families. But we have only scraped the tip of the iceberg, however. The Yazidis' traditional way of life consists of a mother taking care of the home and the father doing the labor outside and providing for the family. The Canadian government has brought in primarily women and young children who have known this way of life for thousands of years. How can we expect them to successfully integrate and become a positive addition to our economy and social fabric in Canada if we are setting them up to fail and be forever reliant on social welfare? They will not integrate or settle successfully. We need to expand the definition of family to include distant relatives for this vulnerable and traumatized Yazidi population to succeed and prosper. We need to amend the definition of family under the Family Reunification Program. Currently, immediate family only is considered. It has been 5 years now since the genocide began, and many still have heard nothing of their immediate family members' whereabouts, or they have already been confirmed dead. Just as a special program was created by the government to sponsor Yazidis, we now need our policies to reflect the realities on the ground, and to be understanding of the special circumstances surrounding this traumatized Yazidi population. 5 years since the Yazidi genocide began, and it's still ongoing today. The Yazidi women who face the most barbaric attacks from ISIS are seeking answers and justice. In Iraq and around the world, different steps are being taken to help, and victims are beginning to heal. For example, countries such as the UK and Germany are starting to collect evidence in order to pursue legal actions against the perpetrators and justice for the victims. In Iraq, a group of investigators was sent under Security Council Resolution 2379 to collect evidence of war crimes, crimes against humanity, and genocide acts by ISIS, and to begin the exhumation of mass graves. As I work with the Yazidi women in Winnipeg and have spoken with the Yazidi community around Canada, there is a consensus that justice to them right now is to be reconnected with their family members. This is one of the main reasons the Canadian Yazidi Association has been prioritizing the reunification of families. A couple of months ago, members of the Canadian Yazidi Association went door to door to every Yazidi family in Manitoba and recorded the names and information of family members who are still left in Iraq. We have recorded just over 1,000 names. We have the capacity, the will, and the financial means to reunite these families and allow them the opportunity to live a successful and productive life in Canada. But a political will of action must be present for this to happen. We hope our government will do the right thing and allow these vulnerable families to be a whole again. Thank you.
Thank you for your comments, Ms. Nasso. Mr. Booz.
Thank you, Mr. Chair, for the opportunity to appear before this committee once again regarding the proposed change to Canada's asylum system as outlined in the BA, in the Budget Implementation Act. Providing technical advice to increase efficiencies in asylum system is an integral part of UNHCR, the UN Refugee Agency, advisory role worldwide. And we support any measures that ensure prompt decision-making while upholding the essential element of a fair asylum system. While the number of asylum seekers arriving in Canada increased over the last 2 years, I have previously noted before this committee that measures taken have maintained access to asylum in a humane and efficient manner with adequate security checks. UNHCR recognizes that governments, including Canada, must strike a balance between managing migration flows, ensuring border security, and maintaining public confidence in asylum and immigration systems. In doing so, they must abide by their international obligation to grant refuge to those at risk of persecution. In this context, mixed flows and onward movement from countries like the United States may be perceived, in particular by the general public, as a misuse of asylum. This was referred earlier on. It is therefore legitimate for governments to take measures to address such concerns and find ways to triage cases to ensure fair, efficient, and robust processes in a timely manner. UNHCR welcomes important investment to Canada asylum system in the 2019 budget. They build on increased efficiencies gained over the last few years, and the recent proposed legislative changes that we are discussing today form part of a broader strategy. They include a significant increase in funding to the police, border agency, legal aid, and the Immigration and Refugee Board. They seek to increase cost-effective efficiencies at the front end of the asylum process. Investment in refugee health care, as well as housing, will also benefit refugees and asylum seekers. Under the proposed changes, as we have heard today, individuals who have made an asylum claim in other countries with whom Canada has a data sharing agreement will be barred from having their case heard before the IRB. However, they will not be barred from claiming asylum in Canada or from being recognized as refugees. Indeed, they will be channeled through the pre-removal risk assessment, also known as PRA. The PRA has the same protection objective as the refugee determination process at the IRB. It is based on the same grounds and confers the same degree of refugee protection. In other words, the same definition will be applied to assess whether someone is in need of protection in Canada because of risk they may face in their country of origin. I would like here to take a moment to discuss a concern often heard recently. It is true that the PRA has an acceptance rate of 7% when it provides a last recourse measures after a negative decision by the IRB and the federal court. This low acceptance rate suggests that the IRB and the courts are performing their mandate in an effective manner. However, the acceptance rate goes up to approximately 30% when it is a first instance mechanism. It must also be noted that based on the last 2 years' data, some 3 to 4% of claimants will be channeled to the PRA as a first instance mechanisms. Any discussion around acceptance rates should, however, be taken with a grain of salt. What ultimately matters is that no individual is forcibly returned to a country where he or she will be at risk of torture or persecution. And every case must be assessed against its own merits. Protection safeguards built into the PRA process must now be fully utilized, and all stakeholders have a responsibility to make sure that they are used to ensure a fair PRA process. We have heard Minister Blair explaining those measures. Under the enhanced PRA referred to by the government, UNHCR has received assurances that no one will be removed without due process, which notably includes the right to a hearing prior to removal. This is in line with Canadian and international jurisprudence. Asylum seekers falling into this new stream will need to continue having access to information about the PRA process, effective language interpretation, and access to counsel. Similarly, PRA officers will have to be trained further, specifically on how to conduct individual hearings in a fair and efficient manner, including by ensuring that counsel plays their role fully through intervention during the course of the hearing. And again, we have heard both ministers and civil servants explaining the measures that are now contemplated. In the past, UNHCR has also advocated for the reduction of procedural steps throughout the front-end case process that cause delays and increase cost. Our recommendation included exception for people coming from moratorium countries to be given a protected person status, given that they cannot be returned home, and automatic stays of removal during appeal on negative asylum decision. UNHCR is looking forward to lessons learned from the various pilots that relate to interinstitutional coordination on case processing. That was referred to the example of Montreal, simplification of data collection and forms, triaging and streamlining. In addition, timely removal of those not in need of international protection after all available remedies have been exhausted and due process completed will continue to be key to guarantee an asylum system that is fair and efficient and thus maintains the public confidence. UNHCR has long supported the IRB and its independence as a model and continues to do so. Finding ways to increase efficiencies through better triaging while upholding access to fair procedures are, however, legitimate. In discussing these complex realities, often of a technical nature, we all have a responsibility and must work together to ensure that the conversation about asylum and refugees remains objective and balanced, based on sound legal analysis and fact. Asylum system must at times be flexible to address changes in the patterns and profile of asylum seekers to remain fair, cost-effective, and efficient, thus ensuring public confidence in their integrity. Thank you.
Thank you very much, Mr. Buzz, and thank you to all of our guests for keeping their representations timely. We'll begin now with Mr. Sarai.
Thank you for all your presentations. I'll first ask Mr. Luprecht. You spoke about the three kind of ingredients that make a successful immigration policy, and I won't go over them due to time, and you're a fellow at the NATO Defense College. How do you think this legislation, proposed legislation, it will be perceived by at least the Five Eye partners of ours who are members of NATO as well? Have you ever had any conversation with them, or is it in line with similar similar language maybe used by any of them?
So I think that's a very apt question because, of course, the challenges that we're discussing here are not unique to Canada. They're challenges from across the world. And I think one way to sum up the problem is the supply of potential migrants greatly exceeds the fiscal and social capacity of most receiving countries, as you point out, and the effective management of immigration policies is vital to our continued prosperity, social cohesion, and democratic legitimacy. And I think because Canada has, so much of the world looks at Canada for being able to build a successful model, not just in terms of immigration, but what's unique in Canada, especially since the mid-1990s, and Keith Banting and Stuart Soroka have done some very interesting work on this, is actually the increase in popular support for immigration policies at the same time as we've raised the levels of immigration. So these are not necessarily negatively correlated.
Okay.
And so I think it is important that Canada is able to, in terms of the problem that I laid out, to lead by example, because so many other countries are struggling with this. And I think there's a risk that, in light of the challenges that I've laid out, and I think this is sort of the struggle that, so one of the uniquenesses in Canada is that 95% of people who come to Canada are people that Canada selects, and 5%, a little bit larger since 2016, are people who just show up. In Europe, we have the opposite challenge, where 95% of people are people who just show up. And so I think within the Five Eyes countries, there's a sense of that because of our unique geostrategic situation, we have an opportunity to build and ensure we can coordinate a system that is legitimate and sustainable. And so I think if we can't find a way forward that effectively deals with the current circumstance in terms of irregular migration, I think it will send a signal to our partners that there's probably not much hope for especially our European partners, for instance, within the Dublin process, to find a measure of coordinating effectively on refugee policy. And I think the medium-term strategy within the Five Eyes, and I think most people sort of understand this also with the cooperation that we have, has to be a somewhat more harmonization of the way we approach this particular issue. I think, but there's a high level of awareness of exactly the problem you lay out.
Thank you. Mr. Bruce, you had commented in the Globe on April 16th, the federal government's tougher line on asylum seekers is no cause for alarm. Can you explain this?
Those were the words used by the journalists. What I've said precisely is that indeed the measures contemplated now under the Budget Implementation Act are not violating any international obligation of Canada, because refugees will still, asylum seekers will still have access to the PRA, by which they will be assessed in terms of their risk of persecution. And since we heard that the government is ensuring that this will be done through a hearing with the right of a counsel, legal advice, this meets also the jurisprudence of both international mechanisms and of Canada, ensuring that there is a proper hearing before somebody is removed from this country.
You monitor migration patterns and asylum claims around the world due to the nature of your work. Do you think people migrated to Canada because of a tweet by the Prime Minister, or because of the global conditions that have displaced 23 million people?
I've had the opportunity to clarify this point. It's very clear that people, there are push and pull factor for people to cross international border and to seek asylum. Every case is individual, and I think it will be inappropriate to think that people who are fleeing persecution will end up in Canada just on the basis of a tweet. They do that as a last resort when they feel that their life or the life of their loved one are at risk. They take a number of risks in doing that, including having some time to resort to smuggler and trafficker. And it's also why it's important that we keep the integrity of the asylum system fully respected.
Do you think Italy or Greece made any similar types of tweets in 2015, 2016 that justified their large numbers that sailed across the Mediterranean Sea to seek asylum?
Again, I repeat, I don't believe that a tweet or any particular statement being made by government official here or there in other countries triggers a movement. People have difficulties leaving their home, have difficulties crossing an international border, and do it only as a last resort when they feel that it's the only way to protect themselves and their loved one.
And do other legislations, I asked Mr. Lepret earlier, but do you know of other countries, the Salem destinations perhaps, where countries have made similar types of legislation where if you've claimed asylum somewhere else, you cannot repeat it elsewhere? Has there been similar type of legislations, or is Canada kind of the leader on this, as he said, in terms of expectations on immigration and asylum?
Asylum countries are finding ways to triage cases to make sure that they find the most effective, but also the most cost-effective ways of assessing who is in need of international protection. It's important that those processes remain robust and fair, and this is the case with the measures that have been contemplated now by Canada. But it's also important that we ensure that people are being processed in a timely manner so that they don't remain asking questions about whether they will be able to remain legally in the country where they have sought asylum. And therefore, European countries and other countries have been contemplating or have been enacting similar measures of triaging cases.
Thank you. We're 20 seconds over time, so we're moving to Ms. Rempel and split with Mr. Tilson.
I think so. We'll see.
You're going to take all the time?
I'll start with Dr. Luprecht. You've written extensively, I think, about human smuggling and some of the issues. I was going to go on that, but I just want to touch on some of the comments that you were making with regard to the Dublin renegotiation and sort of the coordination of asylum system reform. It's my understanding that Canada can operate the Safe Third Country Agreement with the United States and still be in compliance with our international obligations because of some of the provisions that are in Article 19 of the Geneva Convention, which, again, are there to prevent asylum claim shopping, and how the agreement is structured. It seems to me that Division 16 of the Budget Implementation Act of Bill C-97, I think we're at, or whatever it is, that I think, I'm not sure it's going to survive. First of all, I don't think it's going to survive a court challenge in the Canadian context. It doesn't really impact people, like the minister just said, it's going to be impact about less than 10% of the people who have entered Canada from the U.S. In the loophole in the Safe Third Country Agreement and claimed asylum over the last few years. And for that reason, my position has been that we actually need to undertake, and one of the roles Canada could take is global asylum system reform, where we're looking at a network of safe third country agreements that we could use international fora to really lead a discussion on what constitutes a safe third country, what monitoring agreements need to be in place in order to ensure that those happen over a long period of time. But I don't think that Division 16 is that. I think it's a last-minute shortcut is kind of how I read it, that probably isn't going to work. Would you say that that assessment is correct or in the right ballpark?
Look, we have to start somewhere. I think given the current situation, I think I always say hope is not a method, and just sitting here and hoping something's going to change in light of the factors that I pointed out is not going to happen.
I know, and in this situation, though, like, this is not hope. There's something on the table, but if it's likely to be heavily litigated within the Canadian legal system and cost the government a lot, and then appeals, and then grandfathering, and blah, 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 as we often see, would that hope not be better placed in taking concrete action? I mean, I look at, I was in Europe last year meeting with, European parliamentary colleagues of all political stripe, the Dublin renegotiation. So it's a start, but it, again, doesn't offer a lot of hope. And I'm just wondering if perhaps what Canada should be doing is really taking a leadership position and saying, look, we support asylum claims. We don't support asylum systems being used to facilitate economic migration. And here are the venues by which economic migrants can come into Canada, which is, frankly, I think, really calling a spade, what's happening in Canada right now.
So I think the Dublin negotiations, as you know, with regards to refugees are at an impasse. And I think one of the things that Ken needs to think about, yes, we need to establish an international regime among countries that are sought after as destination countries, ultimately. As the bill points out, we already have, and Mr. Sarai also pointed out, we have a Five Eyes arrangement emerging, and that's the most likely prospect that I think we build this bottom up. At the same time, I think we could do better at having, how can we incentivize better behavior by people, for instance, within the Dublin process that are the veto players? And I'd suggested, for instance, even at the time when the government decided to admit a significant number of Syrian refugees, that we could perhaps use some of the numbers that we have at our disposal to incentivize the sort of agreement that the Europeans are currently lacking, by saying that Canada will bail out, for instance, some of the countries that are veto players in the Dublin process currently for X number of years. So these countries can very slowly not only ramp up systems, but
that
can
sounds
also,
like a lot of money.
It's
but so if I may, just because I'm running out of time,
we're gonna need incentives.
I just want to go to Nafia, Ms. Nasso. I'm going to ask you a very simple question and give you the rest of my time to answer it. Really, at the heart of this conversation is a conversation on who should have priority access into Canada's refugee and asylum systems. And I just want to give you some time to articulate your position on that and why.
Okay, thank you. Where do I start? I work as a full-time settlement coordinator, and I assist Yazidi refugees. My job was to assist the privately sponsored Yazidi families, and the wave of the GARs that came in, we're now assisting them. And it's, I mean, the families that have come in, they're all broken families, young mothers with lots of young children. We're constantly getting calls from extended family members back home who are left in refugee camp. There's hundreds of thousands of Yazidis struggling in refugee camps in Turkey and Iraq today. We have well over 3,500 Yazidi children, women who are still held captive by ISIS. One of the biggest projects that we're working on right now is to work with all levels of government to reunite some of these families, and we're talking about, for example, dealing with a family right now who is here with a stepmom and 3 step siblings. She about a year ago found out that her 17-year-old brother was alive, and he managed to escape ISIS, and he was actually bought back from smugglers for $14,000 US. We put in an application forward with the hope that the government will reunite these siblings. The application was rejected. Why it was rejected? Because the parents, they need signature of the parents. Well, the parents are missing and probably dead. So these are the things that need to change for this specific population. We're talking, when we say broken families, these are families who, for most part, a lot of people who are missing. So the family reunification, when we say we need to amend the definition, it needs to be not just parents and siblings. We need to expand that. We need to include.
Thank you very much, Ms. Nasso. Okay. I'll now move on to the next round of questioning. Ms. Kwan.
Thanks very much, Mr. Chair, and thank you to the witnesses. I'm just going to build on what Ms. Nassel said for a minute here and let her finish her thought, because I think that it is a very important point for her to present and to call on the government, if I understand her correctly, to expand the definition of family beyond just parents and children, underage children for sponsorship, but rather to move beyond that, to recognize siblings as an example. And some would argue even aunts and uncle, because many different communities define their immediate families differently. Am I correct in interpreting that?
Yes, you're correct. Thank you for that.
Thank you. And by the way, Canada used to have a program that allowed for siblings to sponsor each other. That's how I came to Canada. My family, my aunt sponsored my dad and a family of 8 to come to Canada. And that's how we made Canada our home. We should actually go back to the system and extend that to the refugees. Thank you so much. I do want to turn to the UNHCR for some of my questions. The UNHCR wrote a 20-page report speaking out against the 2012 Harper government's changes to the refugee determination system under Bill C-31. That was back in May of 2012. Amongst other things, there were a number of key recommendations. One of them is for the UNHCR is recommending against the differential treatment of refugees and asylum seekers where it infringes on established rights of refugees. As far as we can see, as far as I could see, under Bill 97, there are different treatment of refugees under different streams now. So why is it okay now in this stream and it wasn't okay back in 2012?
Thank you very much. It's important to remember that patterns and profile of asylum seeker change over time. And the situation in 2012 and the situation in 2019 are radically different in terms of the numbers, but in terms also of the profile of people who arrive to this country, including through irregular means. That's the first point. The second point, we clarified, as you noted, that it is about procedural guarantees. And as we have heard today, under the PRAS, this new stream of people will still have the guarantee of a hearing and the right to a counsel who will be actively participating into the discussion. It's not about the body, it's about the procedural guarantees that are afforded to asylum seekers to ensure that it's a fair process.
Well, thank you for that. I would argue that irregular crossers who come over, and in fact, so far under our IRB determination process, more than half of them have deemed to be valid claimants. That said, I'm going to park that for a minute. So however they cross over, that is not really the issue, is it? Is whether or not once they get to Canada, do they have access to a proper process? And that's your point. So, okay, so you say that under Bill C-97, there is a proper process for them. I would beg to differ because right now, those who are made to go through the pre-removal risk assessment process would not have an appeal process to them. And so the UNHCR back then recommended that all asylum seekers have access to an appeal on the merits to the Refugee Appeal Division. And so under this system, people, when they go through the pre-removal risk assessment process, there is no appeal for them to go to. They cannot go through the RAD process. OCASI, in fact, an organization in our community, spoke out against that and who were deeply concerned that Bill C-31 would create a two-tier system of refugee protection in Canada, which would result in some claimants being denied the right to appeal. That is what's happening right now under Bill C-97. So why is it okay now and not okay then?
I beg to defer to your interpretation. They will have a right to appeal to the federal court, which is in line with both Canadian and international jurisprudence.
Well, people who go through the pre-removal risk assessment process do not have the right to go through the RAD.
Can appeal to the federal court, and UNHCR has been very clear, and international jurisprudence is very clear. It's about a fair process, which is entrusted to the federal court, which I think amongst all of us here, we can agree is a robust mechanism to assess whether the PRA officer may have missed some element in the determination whether the person needs to be protected as a refugee in Canada or not.
Yeah, I mean, I would be interested too in looking into the access to federal court and how difficult it is for refugee claimants to access that procedure and that process and to get the representation so that they can, in fact, have the due process and fairness afforded to them. I would argue that most people do not have that access.
This is why we were very pleased to hear that the minister confirmed that they will have access to legal counsel.
Well, the ministers say that the process is there, but who would actually really be able to access it remains another story and another issue to which asylum seekers, many of them, as we know, do not often have access to legal representation and therefore access to court procedures.
So we are very pleased that the federal budget increased the legal aid.
Well, actually, we just heard in the Ontario, legal aid, in fact, is being cut. And in fact, refugees do not have access to it. But I do want to actually go into this other issue, too, because we clearly differ in that opinion. But I would go into this. The UNHCR also recommended that the removal of the 5-year bar for designated foreign nationals to file an H&C application from the date of decision or the date of destination. That was back in 2012. And so now, under Bill C-97, there's an also bar for people to make application under H&C. So again, I ask this question. Why is it that the UNHCR now is silent on the current expansions of the H&C application bar?
We do hope that mechanisms will be put in place for those who need to have an HNC to be able to receive the protection of the HNC. And as I have mentioned in my statement, we are kindly suggesting that there is also a stay of removal pending a final decision by the federal court for all cases, not only those who are part of this new stream, but also for those who previously, under previous provision of the law, may be at risk of being deported before there is a final decision by the federal court.
Well,
Ms. Kwan, I'm going to allow you to have another minute because of Ms. Rempel going over, but we're at 7 minutes now, so I'll be strict.
Well, thank you very much, Mr. Chair, for that extra minute. With respect to the bar for H&C claims under Bill C-97, a group of refugees would not be able to access H&C claims under this current system. Effectively, what that means is that some individuals would be denied that opportunity. And I raise this issue because I think what's really important is this, that at the end of the day, what Canada's got to live up to is to ensure that, which is the original position of the UNHCR, and that is for every refugee to have access to the same process with respect to refugee determination system. And that is what is at risk right now under Bill C-97. So thank you, Mr. Chair, for that.
I just want to repeat, it's the same procedural safeguard.
Thank you very much, Mr. Booz. Given the time, the last round of questions will go to Mr. Ayoub for 7.5 minutes.
Merci, Monsieur le Président. You'll need.
Thank you, Mr. Chairman.
My question is going to be in French, just to make sure. Monsieur de Buz, écoutez,
Mr. Buz, I've been listening to the round of questions. Canada's always been considered.
Just to hear all the question and so by respect for her. Je sais pas. Patient, oui. Peut-être. You ready?
So Canada has always been considered and is increasingly considered a country of refuge. And that is why there's been an increase in asylum claims. But like Mr. Leprecht said, we have a geographic situation that allows us, I think you said 95% of newcomers have been chosen, selected to come to Canada. So the idea is to strike a balance between what we have to do, what our international obligations are, and what Canadians are willing to do, the number of immigrants Canadians are willing to receive. And that's government's role, and that's what we've done in recent years. I'm always concerned. I always have a concern when I hear the double talk, the hypocritical political rhetoric around immigrants and refugees. Parties are calling for us to block some refugees, to bar access, because there are financial considerations when you have to provide better funding for services, for refugees, for people who need temporary housing, and so on. So the misinformation is spread, but at the same time, we on our side want to make sure that there's quality, that people are safer. We need to reassure the Canadian public so that our country continues to be welcoming to new arrivals. So how are things right now in terms of refugees' rights when people are rejected, when their claims are rejected? They can appeal. And earlier it was asked, who's going to be able to help them? Will they have access to legal counsel? I'd like to hear what you have to say about that, Mr. Buzz. When it comes to asylum seekers who have not been recognized as needing Canada's international protection, they have a right to appeal to the federal, even including to the federal court when they've been rejected on a PRA. So all rejected claimants are supposed to be returned to their country of origin. Of course, there are other steps to provide for their resettlement. Often they left their country of origin because of poverty or lack of employment. So there are other things that can be done for those people. But I think it's important that the signal that's being sent today is be careful. Don't use asylum in Canada as a way to come here as an immigrant. If you want to immigrate, there are different procedures in place for you. So don't waste your money. Don't endanger your lives, whether it's by taking a boat or by having recourse to smugglers or traffickers. So it's not a free-for-all when you come to Canada. And no one should abuse the asylum procedure. So that's the signal that's being sent, but it also sends a signal to people who are entitled to seek asylum, who need asylum, that Canada remains a welcoming country, and there are procedures in place that are similar. They're a bit different because things have to be done more cost effectively and more expeditiously, but the goal is the same, and that is to protect those who cannot remain at home because of a risk of torture or persecution. Thank you. I think I have a couple of minutes left, and I'll give them to my colleague.
If you could clarify for me, because I heard Ms. Rempel mention earlier the need for Canada's leadership on global asylum reform as well. I've heard her talk about the need for Canada to be at the table talking and engaging with the world about global safe third country agreements. Are these not the very issues that Canada is at the table leading on when it comes to the global compact on safe, orderly, and regular migration? Quickly, yes or no?
I think we have a situation where people are dispensing with the formalities of national immigration policies on a large scale across
Mr.
countries.
Lupreck, I'm sorry, do these conversations, are they part of the conversations that are taking place when countries get together at the Global Compact on safe, orderly, and regular migration? They form part of the document. Is that not part of Canada's leadership on these very issues?
We're talking exclusively here about domestic issues. Nothing in this bill suggests to me that Canada is taking cues or
I'm
coordinating
asking you a
with other
question
countries.
about a comment that was made earlier about Canada's need to lead on global asylum reform and on safe third country agreements around the world. Monsieur Buzz, does that form part of the conversation at the Global Compact?
Short and long answer, yes.
Okay. So would it be fair to say then, and you don't need to answer this, that the fear-mongering on that issue that we saw from the Conservative leader before Christmas is completely contradictory to what his critic is saying right now in an area where Canada needs to take leadership? You don't need to answer that. I want to ask Mr. Booz one more question. You're confident with the procedural guarantees that are in place to deal with the new mechanisms in Division 16?
I am, and I hope that at some point the measures which have been described by Mr. Blair will be enacted in a law.
Is there anything the government can do to strengthen those guarantees and ensure fairness in the asylum system, which we know is important to allow Canada to continue to be a place of refuge?
So uphold the decision which has been commented here of having a hearing, a right to a counsel, the possibility to appeal to the procedures, and if there's a possibility to have those procedures fully recognized in a piece of legislation.
And Ms. Nassau, if I can just say thank you for being here today, and thank you for your leadership with the Yazidi community across country, with Operation Ezra in Winnipeg. It's been an important part of this government's leadership on resettlement, and I'm sure we will have more conversations ahead about opportunities to resettle more Yazidis here in Canada. Would you agree it's important that Canadians understand the distinction between a fair and strong asylum system and a resettlement system, which are two distinct processes and systems, but areas that it's important that Canadians be clear upon to ensure that there's acceptability for us to continue being a global leader in resettlement?
Less than 30 seconds, please, Ms. Nassau.
Yes.
Okay.
Thank you very much. Mr. Lloyd-Pratt, maybe if I'll just use a chair's prerogative for the last 10 seconds here. Did you want to add something to the last point that Mr. DeCourcy had made?
And I want to apologize, Mr. Lloyd-Pratt. I was just hoping for a quick answer before we ran out of time.
Right.
But if you're going to allow him,
The reason
I'll
I
allow for it.
I wanted to wait 10 seconds, but the reason I wanted to weigh in is because too much of the conversation focuses around somehow protecting whoever gets here, as opposed to putting the emphasis on protecting the most vulnerable, as opposed to people who are deliberately dispensing with the formalities of national immigration policies. And nothing in this bill does away with the fact that this is the large-scale problem, and we need to address the broader issue rather than putting all this emphasis on protecting whoever ends up in Canada. Let's put our efforts into people such as my colleagues.
And Mr. Lloyd,
Thanks to Mr.
these would be the
and
very
Mr. DeCourcy.
conversations
I think
that
we're
take
done here now.
place at these international
Thank you very
fora.
much.
Would you not agree?
So we'll call this session to order. We'll take a quick break as people clean their plates away from their desks, and we'll invite the next panel, the final panel, up. Thank you. Thank you, everyone. I believe that Ms. Lobad and Ms. Sandra Hassim and Ms. Bayaki. So we're calling now the fourth panel of the 158th meeting of the House of Commons Standing Committee on Citizenship and Immigration to order. With us for this hour, I believe, are Amnesty International Canada, Justin Mohammed, as well as Marilyn Rubaiyaka. Rubaiyaka, thank you. And appearing for the Canadian Association of Refugee Lawyers, Lobat Sandra Hassanmeh.
Sadra Hashimi.
Sadra Hashimi, thank you very much. I'll work on the pronunciations at some point. Each of your organizations will have an opportunity to give a 7-minute presentation, following which we will be able to have one round of 7-minute questions, I believe. Opening it up with the Amnesty International, please.
Thank you, Mr. Chair, and I'd like to begin by acknowledging that we are on the unceded territory of the Algonquin people. That is a particularly salient message to bring in this committee because aside from when we're discussing issues of immigration and refugee matters, aside from our First Peoples, of course, we all have a story that's rooted in migration. Our remarks today will focus exclusively on Section 306 of the bill, which adds a ground of ineligibility for claims of refugee protection made to the Refugee Protection Division of the IRB. I'd like to register our objection to the fact that Canada's refugee protection regime, the changes that are being proposed are in an omnibus bill. We salute this committee's decision to nevertheless examine this issue, but we're dismayed that we were not consulted prior to the tabling of this bill. Over the course of my presentation, I would like to make 3 points. First, Amnesty International considers that Bill 97 is inconsistent with Canada's commitments under international law. Second, the bill will have the negative impact on Canadian refugee practice by creating a 2-tier system of refugee protection. And finally, Canada must not rely on foreign protection regimes to uphold its international obligations. With respect to the inconsistency in international law, Amnesty International is of the view that Section 306 of Bill C-97 is inconsistent with international refugee law because it constitutes an automatic barrier to the referral of a claim to Canada's refugee status determination system, the Refugee Protection Division. It operates without regard to when the prior claim was made, the status of the claim in the other country, whether it be finalized, accepted, rejected, withdrawn, etc., and the fairness of the refugee status determination process in the other country, or whether there are other possible bona fide reasons for which a person may seek Canada's protection after having done so elsewhere. We consider that automatic bars to consideration of asylum claims are not in conformity with the Refugee Convention. The Convention furthermore prohibits discrimination amongst refugees on the basis of race, religion, or country of origin. While the measure in Bill C-97 does not discriminate on the basis of these grounds, it is arbitrary and discriminates on the basis of a claim having been filed in another country, if that country happens to be Australia, New Zealand, the United Kingdom, or the United States, or any other country with which Canada signs an agreement. We view this to be an analogous ground of discrimination to those covered in the Refugee Convention, and thus a violation of the spirit, if not the letter, of that convention. Second, the 2-tier system. Amnesty International further opposes the measure in Bill C-97 because it introduces a 2-tier system of refugee protection. While some refugee protection claimants will have access to the robust status determination system in the Immigration and Refugee Board, others will only have access to the PRA. The UNHCR has previously expressed concerns about this, noting, and I quote, "Where access to the refugee determination procedure is denied and claims are referred to the PRA for determination, there is a risk of creating a 2-tier system in which the protection risks of one class of asylum seekers are assessed by the Immigration and Refugee Board, while those of another are assessed by CAC officials. This could affect both the efficiency of the system and consistency of decision-making," end quote. The UNHCR handbook, reissued as recent as February 2019, says the same. Quote, "There should be a clearly identified authority, wherever possible, a single central authority with responsibility for examining requests for refugee status and taking a decision in the first instance. Amnesty International supports that view because the two-tier model results in important differences, and I will cover them now. First, independence. While the IRB is an independent quasi-judicial tribunal, a PRA officer is an employee of the IRCC. This new system would undermine the long-standing policy in Canada that claims for refugee protection are heard by an independent decision-maker. Second, oral hearings. This is discretionary under the PRA. However, even if an oral interview is afforded, it does not offer the same protections as an IRB hearing. The refugee claimant has no ability to call witnesses or to test the evidence upon which an officer is relying. Third, appeals. Decisions of the RPD are appealed to the Refugee Appeal Division, whereas appeals of the PRA go to federal court for judicial review. Both have different standards of review, and more importantly, while an appeal to the Refugee Appeal Division results in an automatic stay of removal, an application for judicial review does not. Finally, Amnesty International is concerned that Bill C-97 unduly relies on foreign refugee status determination systems where human rights abuses of refugee protection claimants are well documented. The U.S. provides an illustrative example. In our 2018 report entitled "You Don't Have Any Rights Here," Amnesty International documented 3 categories of human rights violations that are being committed by the United States: illegal pushbacks along the U.S.-Mexico border, family and child separations, and arbitrary and indefinite detention. Since that report, there have been a slew of administration policies that fail to respect the rights of refugees. One will deny bond to persons seeking refugee protection until their claims are finalized, which we know can take years. And another would establish a general rule that disqualifies victims of gang violence and domestic abuse from refugee protection. Only last week, the Trump administration circulated a memorandum which intends to further dismantle the system of protection by having U.S. border guards, rather than asylum officers, consider those claims. I'd now like to turn the floor over to my colleague, Marilyn, to provide a real-life example of the type of claim that would be affected if Bill C-97 becomes law.
Je vais m'exprimer en français. Monsieur le Président, Messieurs, Dames les députés, nous aimerions vous...
I'll speak in French. We would like to tell you about the case of someone who, based on the current system, was granted the refugee status that he was asked for. He left Saudi Arabia in 2006 to pursue graduate studies in the United States. At the same time, his father was a prisoner and was imprisoned twice for his freedom of expression. He critiqued the government and its laws. So this individual, this student, started a campaign on Facebook, in social media, defending freedom of expression and demanding his father's release. And in fact, a friend, he in fact was in danger, so he asked for refugee status in the United States, and this was refused to him, despite Human Rights Watch and Amnesty International's efforts. They were afraid of being deported to Saudi Arabia, he and his friend, so he decided to enter Canada irregularly, without papers. And the IRB recognized that this individual should be protected here in Canada. Otherwise, he would face risk of persecution in his own country. And this same case was studied in the United States. The request was rejected. Amnesty International thus encourages this committee to consider the procedural issues that this person would have faced if not able to speak in a hearing. I'd ask you to conclude your remarks. For reasons unbeknownst to him, his request was denied in the United States, so it is Canada's responsibility to ensure that we respect our international commitments.
Or Canadian Association of Refugee Lawyers, please.
Thank you for inviting me to speak. Some people have said that there is no point spending our effort opposing these amendments. They say these amendments are in a budget bill, so inevitably they will be passed into law. I am here tonight on behalf of the Canadian Association of Refugee Lawyers because these amendments are unfair and they're ultimately bad for our refugee determination system. I want us to be in this room together as people who the community has entrusted to make laws that are fair and or to speak out against ones that are not. I want you to think about whether you feel comfortable creating laws in this way, rush through a budget bill, laws that directly affect the rights of some of the most vulnerable people in our community. I'm going to spend my time on Section 306, the amendment that creates a new class of ineligibility. You have heard today from Minister Blair, officials, and the Canadian representative for UNHCR. And you've heard assurances that the changes in Section 306 are not significant, that they won't have a profound impact. Most of their faith seems to stem from promises that are nowhere to be found in the legislation. I don't understand their position. The creation of a new ground of ineligibility is a significant change to our refugee determination system that affects a broad category of people and takes away many important protections from these claimants. This amendment does not only affect claimants who cross the border irregularly. It affects every claimant, no matter how they traveled here, if they've ever made a claim in one of these countries that Canada happens to have an information sharing agreement with. It's not limited only to claimants who are rejected by another country. They only have to have made a claim. It's not even limited to claims you made when you were an adult. Even if you were a child on your parents' claim in one of these countries, you're barred from a hearing before the Immigration and Refugee Board. And so what do these claimants in this broad new category lose? They lose a lot. It's not about tinkering and a few procedural differences. These claimants are losing fundamental rights. They lose the full hearing before an independent tribunal. They lose access to an appeal on the merits. They can't go to the Refugee Appeal Division. They have no protection from removal. If they are reviewing a decision to federal court, there's no automatic stay of removal. And now you've heard Minister Blair today and others say there's no need to worry because these claimants will still be offered protection through PRA. I would first like to deal with what is before us, which is IRPA and the amendments in this budget bill. And then we can deal with the assurances that are nowhere in the law, the so-called enhanced PRA that you heard about today. The PRA is not the same as a hearing before the Immigration and Refugee Board. Any refugee lawyer will tell you that. The PRA is a written process. You fill in forms, you provide arguments in writing to an employee at IRCC. IRPA specifically provides that officers are not required to hold an interview, and indeed they don't. It's extremely rare for them to hold an interview. And even in those rare circumstances, it's not a hearing, as my colleague, as Justin from Amnesty has already set out for you. And we heard assurances today that Minister Blair that there'd be an enhanced PRA. I listened carefully to the testimony, and I am lost. We're told that no one would be deported without an oral hearing. When asked whether by hearing he meant interview, we're told no, it will be a hearing with an official, not an interview. As far as I understand, the government doesn't have the power to establish a hearing process outside of the Act. It's also clear that the department has not thought out how this would operationally work if the department was now going to hold thousands of hearings. First, officers aren't trained to do this. An official today said that officer training to make refugee determinations is the same as members of the Immigration and Refugee Board. I found that answer astounding. It's not true. The PRA was never meant to be a substitute for the RPD. It's a written process that's done after someone has already had a hearing before the Refugee Protection Division. The officers are not trained to do this work. They don't do full credibility assessments. They barely ever hold interviews. They haven't had training on how to appropriately examine a woman who's experienced violence. There's no guidelines on it. They don't have the tools. And second, they don't have the infrastructure to do it. Are they going to create a registry, schedule hearings, interpretation, disclosure of documents? Where are the hearing rooms? None of this has been thought through. It's very easy to give assurances, not put them in law, not even think about it through operationally about how the assurance would play out. Why wasn't this a part of the BIA? If this is such a key protection and it's so fundamental, you should ask, why isn't it in this legislation? And all this points to the need to separate this provision out of the budget bill and study it properly along with these promised protections. The government's assurances also beg the question, if you're going to give everyone a hearing, why create a parallel process? What is the logic in this? It's just going to create more backlogs and more delays. There hasn't been a thorough review of the implications of these provisions, including the gender implications. These provisions disproportionately impact women. For example, the United States. The United States does not recognize asylum claims based on domestic violence, even where the home state doesn't offer women protection from that violence. And Canada has long recognized that domestic violence is a basis on which women may seek Canada's protection. But yet, with these amendments, we would punish a woman who was rejected in the United States or who abandoned her claim in the United States, knowing it would be dismissed. We would punish these women and their children with an inferior process and tell them they're not deserving of a full independent hearing before the Immigration and Refugee Board. I don't know how I would explain to a client who, after living through years of domestic violence, managed to escape and make her way from Honduras to the United States, where she was detained and correctly advised that the United States would not recognize her claim, why after all that, after making it to Canada, she doesn't have an opportunity to present her case to the Immigration and Refugee Board, and she's relegated to a lesser process with a government official and no opportunity for an appeal on the merits. Do I tell her our government believes that she's asylum shopping? This is not about women shopping for better immigration deals. This is about seeking protection and safety, and there's no justification at all for punishing these claimants, and offering claimants an inferior process is a punishment. There are so many things wrong with these proposed amendments. It will not achieve any legitimate government objective.
Thank you very much.
Thank you. Carl urges the committee to reject the amendment.
Beginning with Ms. Said.
Thank you, Chair. Thanks to all the witnesses for coming today and providing your testimony. Clause 306 of Bill C-97 would render an individual ineligible to make a refugee claim in Canada if he or she had already made a refugee claim in another country with which Canada has a data sharing agreement, specifically Australia, New Zealand, the USA, and the UK. Individuals in this situation would be permitted to apply for a pre-removal risk assessment. So could both of you let us know that how would you, what recommendations would you have to make sure that the prior hearing is strengthened, like everyone gets a fair chance on the prior hearing? So would you have any recommendations to make sure that we can strengthen this? I'll start with Mr. Mohammed.
Thank you for the question. Amnesty International's recommendation is that the hearing that's provided for refugee protection claimants be the same regardless of the fact of a prior claim. All of the protections that exist in the IRB, after all, exist for a reason. I think that if we use logic, we can understand that the protection regime that's found in the IRB is there because it's meant to protect the rights of refugees. By hiving a separate process off and putting it in the PRA, I fail to understand where the additional achievement is if we recognize that those are the protections that refugee protection claimants should have in Canada. So we recommend that, in fact, the same protections that are available to a person under the IRB should be available for any person who is claiming refugee protection in Canada.
Ms. Sadr Hashmi, would you like to?
Thank you. I agree with the comments from Amnesty International, and I would just add that I think that it is problematic that we're talking at this stage about recommendations for protections. If these amendments do not provide for a fair process, that's what's before you. If they don't provide for a fair process, then we shouldn't pass it.
But everyone will be getting an opportunity. No one would be removed. Everyone would be given the opportunity under this Bill C-97, Division 16, to have the PRA hearing. So my question was that.
I'm sorry to interrupt, but that's not true. I understand that there has been communications, and I've seen those communications from Minister Blair's office to MPs telling them that everyone will have a robust hearing and an appeal. But I'm sorry, that is just not true. That is not what is in the amendments. That what he's talking about when he says an enhanced PRA, what he is talking about is he's saying that there's an assurance that they'll provide it. That's not what's before you. That's not there.
If they are not eligible to make their claim, they will get a PRA hearing.
No, they won't. They'll get a PRA process. They will have access to a PRA, and under IRPA, PRA is generally a written process, and IRPA is clear that officers do not have to hold an interview. So everything that you're hearing about this enhanced PRA, that's not in IRPA. That's not in the budget amendments. That's not
today
there.
We heard from Minister Blair, and he specifically mentioned that there will be an interview. So that
Yes.
is wrong that there will not be an interview. Today in the testimony, he came here at 3:30 and he said very specifically that everyone will have the opportunity for a PRA hearing.
Yes, I heard him, and he did say that everyone would have opportunity for a hearing. But what he's saying is that's nowhere. If you look at the language in IRPA and if you look at the amendments that are in the budget bill, there is nothing there. There's nothing about the PRA in the amendments. So the PRA remains as it is in IRPA. There is no amendments to the PRA in the budget bill. And so this is a misconception, and it's very unfortunate because this is such a serious thing that's going to affect people, and it's wrong that you've been provided with these assurances that are actually not in the law.
Yes, I'd like to share my time with Mr. DeCourcy.
Ms. Sadra-Hashemi, if these provisions are given a guarantee through regulation, would that satisfy, and or is there a way that this could be strengthened to ensure that the enhanced PRA guarantees an in-person hearing for those who would be part of this cohort that wouldn't be given access to the IRB because they already have a claim in another safe third country? Is there any recommendation that you can make to us that if the new pre-removal risk assessment goes ahead, that we could add safeguards in to ensure an in-person hearing?
Well, I would first say that, as you're aware, regulations are easily changed. So I have a problem with, if these are key protections, if this is how we say that this process is going to be fair.
Regulations can also be strengthened much easier than other methods as well. I mean, to be fair.
Well, I just don't understand. If this is a key protection, why wouldn't you put it within the amendments in the budget? Why would you not? I mean, we haven't seen it. I have not seen any draft regulation, and it's very clear that regulations are easier to be amended and taken away by subsequent governments. And I wouldn't feel comfortable or satisfied with assurances that are in a regulation. And here we don't even have them in a regulation. They're nowhere.
You mentioned the potential gender impact. Do you have any evidence to suggest that it would be women and girls who would be adversely affected by this? Specifically given that, I mean, international UN agency considers the U.S. still a safe third country, and that they have a mature and robust asylum system to adjudicate claims properly. I mean, is there any evidence that would suggest that?
Well, I know you're here. I know there's a witness tomorrow speaking to you about the U.S. asylum system and specifically gender claims. But what I would say is that it is very clear that the United States does not treat claims based on domestic violence the same as Canada does. There's a decision, the matter of AB, the decision of Jeff Sessions. I don't think that's a controversial position. And so all we are saying is that there are very legitimate reasons why women would either abandon their claims in the United States or their claims would be rejected when their claims are based on domestic violence. And I don't see why those women should be punished for that.
Thank you very much, Mr. Sadra-Hashemi. Mr. Tilson, please.
Yes. Well, you're quite blunt. Both of you, I think, are saying that this piece of legislation is beyond help. There's no room for amendments. You don't have any suggestions for amendments. and you're simply telling members of Parliament to vote against it. Would that be a fair? I hope I haven't misconstrued what you said, but certainly Ms. Sadra Hashemi, Lawyer Labbit, that seems to be your position.
Our position is we urge you to reject it, and if not reject it, at the very least, ask for it to be separated out of the budget bill and a standalone bill to be properly debated.
Yeah, the government won't do that. Sir?
Yes, that's correct. We think that that the protections, and I'd just like to reiterate some of the positions we looked at the budget bill, and again in section 306, the provision that we're looking at says nothing about enhanced protections, and this is a problem because it is beyond a repair in that sense. There's nothing that would give an equivalent protection to the protections that are currently existing in the Immigration and Refugee Board, and those obligations that are there under the Immigration and Refugee Board are there for a reason. They're there to protect the rights of refugees.
Are there any other reforms with respect to the asylum claim system that you would recommend? In other words, I'm getting back to the question as to should there be any amendments made. You may have some other ideas as to what what amendments could be made to this. You've told us to vote against it. I understand that. You couldn't be clearer. But do you have any other suggestions for reforms to Canada's asylum claim system? Either one of you.
Well, I mean, generally, our position is that these kind of major legislative reforms to the asylum system shouldn't be done in a budget bill. I would say that if we're going to be talking about all these protections that people are going to be given, then one would expect that those should at least be included. If you're going to pass an amendment based on the assurances that people will not be removed while they're judicially reviewing their decision, or that they will everyone will get an oral hearing, at the very least you would expect to see those as part of it.
Amnesty, Justin?
I have nothing further to add.
No. I have no other questions, Mr. McGuire.
Thank you. Ms. Lovett, or Sadra Hashemi, pardon me. You're very clear. I think both your presentations are very clear in regards to what's not in the bill. I mean, if there's nothing in this, if it's put into this omnibus bill in the manner that it has been, why do you suppose this was even put in the BIA?
I can't speculate on that. I don't really have
any comment at all?
I also wouldn't offer any speculation on that.
I mean, it's curious that the timing is such that we've got a month left in our session here. And there's an election this fall, so I'm just wondering if you had comments on that. There's a number of things that, as my colleague has pointed out, get into omnibus bills that maybe shouldn't be there. And one recent one is called deferred prosecution agreements. Comes to my mind as well, and I think that's been thrashed to death by everyone in the whole country for the last 4 or 5 months. But so I'm just, you mentioned as well that there was nothing about enhanced protection in Section 306. Can you just expand on that?
Yes, Section 306 only provides that it creates this new class of ineligible claimants. It says that somebody who's made a claim in a country that Canada has an information sharing agreement with will now be ineligible. Mm-hmm. But there's nothing about the PRA. The reason that they would get PRA if they're ineligible is because of IRPA. And so there's nothing changing the normal PRA process in this in the budget bill.
So there are areas there that perhaps amendments could be acceptable. When you were asked before, I mean, if there was an amendment to be made, that might be one of the areas that you could do something with it. I would totally agree, though, that it probably should have been put forward as a separate bill. in that area. So one of the comments too was that basically we've lost our sovereignty by going this route. Is there any comment on that?
The only additional comment that I would offer on that is the notion of relying on protection regimes in other countries is it's limited at this point in the bill to, many people have referred to them casually as the Five Eyes countries. Those are the countries with which Canada has signed an information sharing agreement. The issue is that the bill says nothing about the Five Eyes. It says nothing about the countries which I and others have listed here. It talks about countries with which Canada has signed an information sharing agreement. There's no limitation on which other countries might sign such an agreement in the future. And so parsing out Canada's international legal obligations to other countries, think what you will of the four that are currently included in with the information sharing agreements as they exist now. That's where the issue is, that there's no discussion about the potential addition of other countries. And then, just to reiterate, the problems of claims that exist in other countries. I've given the United States as an example here, and there have been recommendations and responses that suggest that the United States is a country of the rule of law. It is a country where there still is a Congress that operates functionally. And what I would suggest to the committee is that while the Congress or the judiciary of the United States may trim the excesses of the Trump administration as it relates to refugees and refugee protection claimants, those changes take time to take place. In the meantime, there are people who are impacted by these decisions right now.
Thank you, Mr. Mohammed.
Thank you.
We'll move on now to a next round of 7-minute questions by Ms. Kwan.
Thank you. I'm going to let Mr. Mohammed to finish his thought and then have some questions.
Thank you, Ms. Kwan. The finality of that point is just to say that there are people who are impacted by this decision right now. The decision of former Attorney General Jeff Sessions that was referred to by my colleague of AB stands right now. It is applying to people right now. And until those excesses can be trimmed by the Congress or the judiciary, if they are trimmed, and to the extent that they are trimmed, there are people who will be affected by those changes until that time.
Thank you. Well, first off, I'd like to say thank you to Ahmed and Ms. Rubayakika for presenting Amnesty's position. Actually, after listening to Minister Blair today, I actually came away thinking, gee, has Amnesty changed their mind? Are they now in support of this provision? And so I'm really glad to hear the clear presentation from you in terms of where Amnesty stands. And so on the issue around the fact that refugees and asylum seekers are going to be faced with differential treatment here in Canada under these provisions, because that is what is before us at the moment. And so earlier today, UNHCR's representative argued that because the pre-removal risk removal assessment process is in place, and where a person is rejected under that process will have access to the federal court as an appeal mechanism. So then, therefore, they everything is fine. They will have a fairness afforded to them. So I just like to actually get your comments about that. Maybe I can start with Ms. Sadr Hashimi, and then we'll go to you, Mr. Mohammed.
Sure. A judicial review at federal court is totally different than an appeal at the Refugee Appeal Division. Judicial review at federal court first has a leave requirement, so you have to actually ask permission of the court to even hear your case. It also isn't a full appeal, so you can't present new evidence. It's not a full appeal on the merits. Even if you win at the federal court, they can only send it back. They don't actually have the power to say that you are a refugee, like the Refugee Appeal Division does. And they also most times are reviewing on a reasonableness standard. They're looking at whether or not the decision was reasonable, not whether or not it was actually correct, because they don't actually have the power to even say that you are a refugee. That's not in their authority to do. So they're fundamentally different. And on top of that, people who are rejected from PRA, they don't get an automatic stay of removal while they're filing leave and judicial review at federal court. You cannot be removed when you appeal to the Refugee Appeal Division, and you also cannot be removed when you judicially review a negative decision of the Refugee Appeal Division to federal court. So it's totally different what is going to be granted to these claimants, what is lost to these claimants, really.
Mr. Mohammed, anything else to add to that? I have nothing further to add. No, thank you. Okay, I'd like to touch on this notion. Somehow the government, the minister, impressed upon us that there will be this enhanced process for PROD. Yet we don't know who's going to be doing it. They're in the hiring process, and they don't know what sort of training would be required. And so we actually don't have very much information about that. And then more to the point, or equally important to the point, is this: if they're going to make people go through that new process or that enhanced process versus that of the IRB, and the official suggested that they were equal or that they were the same. If all things being equal, why establish then a new process? Why not go through the IRB as it is established that is a well-founded and well-respected independent process? I wonder if anybody would like to jump in and comment on that.
Yeah, I agree with that. I think it doesn't make a lot of sense, especially now. The Auditor General has said that he didn't think that thought the IRB was capable of hearing claims that just needed resources and efficiencies, and the IRB actually, the RPD has exceeded its targets in the last year. There has been this new investment in the IRB. So why at this stage are we creating a parallel process that's inferior, that's going to require a lot of resources and infrastructure?
One of the issues that was raised is this. According to the Auditor General, they're projecting another 50,000 claims per year. The officials told us today that 3,500 claims would be pushed through to the new enhanced process. So that would leave us 46,500 claims that would actually go through the IRB, assuming that that would be the process to which people would follow. And so really all intents purposes is a small number of claims that they're jeopardizing the entire fairness process for asylum seekers. And what the officials said is that, but that's not the only reason why they're doing it. They're doing it as a deterrent. So then I guess to the question from Mr. McGuire, I think it was, to say, why do you think the government's done this? I would speculate this. Are they not doing this just so that they can say now, 6 months to an election, they would jeopardize the rights of refugees and risk their lives, and then to say that we're now getting tough on asylum seekers for 3,500 claims? Would I be wrong in thinking that way? Or do you have any comments to add to that?
I don't have any comments on that.
I won't comment specifically, except for one piece that you brought out, which is with respect to deterrence regimes. And I think that this is something that Amnesty International has documented carefully, like in the report that I've referred to, and elsewhere in the continent. And we've had discussions. Our Americas director was in Canada to speak about some of these issues. And the reality is this: that there are deterrence regimes that are being put in place in many countries. The example that I've given here is the United States, and that deter a problem that is much more expansive in some other contexts than the one that we see here in Canada. That's not to diminish the challenge that we see here in Canada. It's just to add the context of understanding that right now in Venezuela, there are 3.4 million asylum seekers on the borders of those of the countries that surround it. Canada is not dealing.
To wind this up.
Sorry?
I need you to summarize your point.
Thank you, Chair. I would just end that point by saying that this needs to be put in context and understood in the context of the North American hemisphere. Canada is largely absent from that problem. Thank you.
And the final round of questioning to Mr. Tabara.
Thank you, Mr. Chair, and thank you for the witnesses for being here. So we've been in committee for a number of hours now, and the previous panel, there's the UN representative, Jean-Nicolas Bose, and he said that this new measures are not in violation of international law. And I think in your testimony you were saying that this is a violation. I just wanted you to just comment on, if you were here for the previous panel, what would you comment on the representative? I'll start with Mr. Mohammed.
Yes, thank you for the question. I won't repeat the testimony that I've given already with respect to why Amnesty International is of the position that this is inconsistent with international refugee law. I'll just add the idea of protection elsewhere regimes and other similar measures have been studied by refugee scholars who have also talked about the philosophy of excluding certain claims from refugee protection. And namely, in this circumstance, we have an analogous ground that can be drawn out. The notion that the claimant has access to protection in another country before making the request in Canada. And even the UNHCR recognizes that there may be reasons for which a person has made a claim in another country, circumstances can change, the protection regime in the other country can change, and that as a result, Canada cannot fail to meet its international obligations by failing to consider that claim.
If I might, if that were the case, wouldn't a strengthened PRA determine that that person wouldn't be sent back? And just maybe I'll ask the same question that I asked your colleague earlier. If it was more clearly articulated what that process looked like and that the adequate safeguards were in place to ensure that there was the type of hearing process that meant our obligations, would that satisfy Amnesty International, even if not all the way, some of the way, in ensuring that we are upholding our obligations to asylum seekers who come to our country?
Thank you for the question. I have difficulty in responding to that. And again, it's a reason that I think was referred to by my colleague. Effectively, you're asking me to comment on something that's not in law. It's not in a bill. It's nowhere for me to see.
I'm asking for your recommendation on how to strengthen the law and strengthen the bill to satisfy Amnesty's view of it.
Right. And in that respect, I'll return to the comments that I had made previously, that the protection that's required is there. It's the IRB. It's what we have in the IRB. So if you're looking for recommendations to what it is that protects adequately the rights of refugees, look to the procedure that's in the IRB.
But Mr. Mohammed, you just said when a person is determined to come to a country, before we can remove them, they go through a PRA process. What we're saying here is that anybody who came and was part of this cohort where they had previously claimed asylum in another safe third country, they would get not only a PRA, but an enhanced PRA, which would determine their safety should they be sent back to their home country. And if they were deemed not to be safe to be sent back, we wouldn't send them back. They would receive protected status here in Canada.
I may have lost somewhere in the question, but you made reference to a safe third country. That's certainly nowhere in my testimony. The discussion about the refugee protection regime as it exists in the 4 countries that would currently be captured by this legislation have deficiencies in their protection regime that may give a very valid reason as to why they would be seeking Canada's protection as opposed to the protection of one of those other countries that are listed as having an information sharing agreement.
Canada would rely on the advice of the UNHCR as to which countries would be deemed safe for asylum seekers. I mean, that's been a long-standing tradition of Canada to ensure that we rely on these international agencies with the expertise they have to help us make those types of determinations. I mean, I think governments of most stripes would at least agree with that, certainly this government, and if there's a way that we can ensure that there was a pre-removal process in place with the safeguards to make sure we weren't sending someone back to an unsafe country, we would do that. And I'm looking in the context of the bill that's in front of us now, is there a way we can strengthen the pre-removal process and safeguards to make sure we send nobody back to an unsafe situation?
And indeed, with full respect to the UNHCR's position of what they've set out as a safe third country, I think I've also given the committee other resources to look to determine the extent to which the United States is a safe third country. I've pointed to one report. I've pointed to decisions of legal authorities in the United States, and certainly the ongoing public discussion about the measures that are being taken in the United States, I would suggest to you, would result in a different conclusion.
Can I ask you both just concluding comments around the measures that the government has taken, other than this particular measure, which has been met with some, has been met I guess, differently by both your organizations that are helping address issues of irregular migration around the world, helping those who are displaced or are in refugee situations come to this country as resettled refugees or seek economic pathways. The government's work to build the capacity and effectiveness of the IRB to deal with issues in a fast, fair, and final way. Do you see those other measures as strengthening Canada's role in both having a strong asylum system as well as continuing to be a leader in fair immigration as well as in refugee resettlement?
Well, we certainly supported the investment in the IRB. I think that that's what makes sense, but that's why this doesn't make sense. You invest in the IRB that already has a system to do this fairly. Why create this parallel process? I just want to clarify a point because I think there's some confusion. Just to be clear, this applies to any country that Canada has an information sharing agreement with. It's nothing to do with safe third. It's nothing to do with safe countries. There's nothing in it that talks about making sure that the country has a comparable refugee determination system to Canada. It just says information sharing.
Can that be strengthened?
Canada can enter into any information sharing.
Thank you very much. That brings the round of questionings to a close. I'd like to thank our witnesses. We'll have a brief break and then 5 minutes of committee business before we call today's session to a close. Thank you. In camera.